Weather seasons. In the spring, seeds take root and vegetation begins to grow. The weather is warmer and often rainy. Animals wake and return from hibernation, often with newborns. In summer, temperatures are hot and sometimes heat waves cause trouble. Maize, groundnuts, and pumpkin farming is best in summer. In the autumn, temperatures cool again, and this is the harvest season for most cultures. In the winter, temperatures are cold with snow, cold fronts, rain, and sometimes gale force winds. This is our normal way of life here in the southernmost tip of Africa, but that's not always the case, as we on occasion have severe weather like heat waves, super strong cyclones, flash floods, tornadoes, droughts, and many more. Our environment is slowly becoming unsustainable to human life due to rising global temperatures. Catch more of this weather and related issues on Whether or Not every Friday at 10 to 5 South African Standard Time.
$900 Central Africa time on Thursday, the 2nd of October 2017. A very good morning and a warm welcome to the first hour here on Channel 404, Jumbo Africa. I'm Elvis Preston.
A very good morning to you.
Now, we will be with you until 12 o'clock today. Now, on the question of the day, there's still no solution to the social grants payment issue between SASSA and the Post Office. Now, Treasury has now been given until Monday, Kendall, next week, to come up with a solution to this issue.
Yeah, and we want you to get involved with the conversation. So we're asking you, is there political will to resolve the social grant payment debacle?
Now, we do have some comments, but we'll read them a little bit later because we want to get down to the bottom of this. But there's also another focus on our poll today because farmers say that they are under siege as farm attacks are on the rise and that both the media and government prefer to turn a blind eye to the plight rather than taking them serious.
And this for you, the question in this particular regards is, can we talk about farm murders and food security without racializing it?
There's also some comments on that, Kendall, but we'll read them later. But sports news. It was a fantastic soccer night and football night last night.
An absolute humdinger. And you know what? The best thing for us to do is, rather than you and I just talk about it, we want to bring it to you at home and ask you what stood out for you in last night's matches between Tottenham and Real Madrid, as well as what happened out here between Sundowns and Pirates, are just some of the things I'd be thinking about.
Some local soccer and international soccer, we would like to get your thoughts. But right now, it's time to take a look at your news headlines. The lawyer for Zaki Ahmad, another activist who were arrested after occupying the NPA offices in Cape Town yesterday, says they're still being held in custody. National Treasury has until Monday to review the social grants distribution process and came up with measures to resolve problematic issues between Social Security Agency, SASSA, and the Post Office. And business and murder accused Christopher Panayiotis will know today whether he has been found guilty for allegedly orchestrating the murder and abduction of his wife Jade in April 2015. Now, those are all your headlines, but before we get to the news, let's find out from Kendall Makamate what's happening on the sports front.
Absolutely, Elvis. Quite a lot happening on the sports front. This is what we've got going on for you this morning in the sports. For a brief moment, the spectacle of another record defeat loomed large for Orlando Pirates as Mamelodi Sundowns hammered in the goals last night. But the game ended in a slightly more respectable 3-1 defeat for the Buccaneers. In the UEFA Champions League, Manchester City break Napoli down in a 4-2 thriller in Naples, becoming the first English team to ever defeat the Italian giants at home.
Sane can pick up the pace here. He left one behind. Who's hearsay was across. Now it's Sergio Aguero. That's the record. Manchester City's top goal scorer of all time.
Rafael Nadal has made sure he'll top the ATP rankings at the end of the season after he beat South Korea's Chung Hyun 7-5, 6-3 in the second round of the Paris Masters.
Well, that's Kendall Makhamate with your sports news. He will be back a little bit later. But right now, let's get down to your news, your top story this hour. There's still no solution to the social grants payment issue between SASSA and the Post Office. Treasury has been given until Monday next week to review the process and report back to the affected parties. The Standing Committee on Public Accounts and the Portfolio Committee on Social Development are trying to break the deadlock between SASSA and the Post Office with regards to the latter taking over the responsibilities of paying grants from April the 1st, 2018 next year. SASSA, the Post Office and National Treasury will meet with the Interministerial Committee chaired by the President before reporting back to Parliament on Wednesday. Meanwhile, the committees have instructed SASSA to halt the advertising of the tender for distribution of social grants that was scheduled for tomorrow.
I thought it was logical that if we say we're doing mediation, it means that there will be no tendering of anything because we don't know what the outcome is going to be. So I just assume that that one is obviously off.
The tender for the third, if it is still there, must be put on ice. The second point that I'm trying to persuade all of you on that side to accept is that there is no need for competitive bidding. And I hear what you're saying, DG, that you received a letter and you need to respond. We're trying to persuade you to write back to the author and say that there is no need, so the author must feel satisfied, because I agree that she needs to be satisfied. I'm making that a firm proposal.
And that's the reason we're asking you this question. That question relates to the SASSA debacle, and of course we're asking you, is there political will, you think, to resolve the social grants payment debacle? There's the first one here coming from Kutalo, says, President must enter this crisis. So the President must resolve it. Mzondile says, we must stop as the opposition political leaders and parties to politicizing this matter and be supportive in coming up with solutions to the problem. This one from Michael Big M Satole says, honestly, I don't know what's the big deal, because a new company must be appointed via proper tender. The sooner, the better. This is about the needy. And I couldn't agree with you more there, Michael Big M Satole. You can keep them coming and we'll read them as we continue on the question that we pose to you. Do you think there's political will to resolve the social payment debacle? Meanwhile, 8 activists calling for President Jacob Zuma's arrest have been arrested in Cape Town. Now, they occupy the offices of the National Prosecuting Authority to compel it to charge Zuma following the Supreme Court of Appeal's ruling. They gathered under the banner of #Unite Behind Us. Spearheading the action yesterday was the co-founder of the Treatment Action Campaign, Zaki Ahmed. Now, you know that he was known worldwide for his activism on behalf of people living with HIV and AIDS in South Africa. The group marched from the Central Methodist Church on Green Market Square to the offices of the National Prosecuting Authority. They say the president should be put behind bars for his alleged involvement in state capture and corruption in government. He also says that the NPA has refused to let them have access to their medication. They've been charged for trespassing but have not been released. ANC struggle veterans and stalwarts have called for the President Jacob Zuma and some in the NEC to resign and allow new recruits to come in to assist in the self-correcting of the party. Now, this emerged at the memorial service of long-serving ANC stalwart Violet Sarah Matlow at the Pact Acacia Community Hall in Pretoria yesterday.
Remembering their fallen heroine, Violet Matlow left the country together with her late husband Joe Matlow and set up the first ANC offices outside the country. Their home in the Peleng section in Lobatse, Botswana, became a transit point for many leaving South Africa. Speakers at her memorial say the ANC does not embody the principles of people like Matlow.
How many times do they call the elderly people to come in to give them a report and also to listen to the veterans if things are not going correctly? They must go to the veteran and ask them, well, are we correct if we are doing like this and like this? Then things wouldn't go wrong.
We need to be relevant to the issues and circumstances that we find ourselves in. We need to be vocal, like the ANC Women's League used to be vocal. Things would never happen to women and the Women's League keeps quiet.
The family want this unsung heroine to be remembered for her role in the liberation of South Africa.
We want South Africa to remember that there are people who unselfishly gave their lives to the struggle of this nation. People who did not want to be paid for fighting for freedom for this nation. People who were prepared to be deployed to anywhere in this world in order to go and sell our struggle to be supported by foreign nations. And she is one of those people.
Matlow will be laid to rest on Saturday, the 11th of November. Solufelo Matibedi, SABC News, Pretoria.
The state will continue to cross-examine the triple murder accused Henry van Breda in the High Court in Cape Town this morning. Yesterday, van Breda conceded that it would be strange for an attacker to enter his family home unarmed, inadequately prepared, and to use weaponry from the house. Van Breda alleges that an intruder hacked his parents and older brother to death and injured his sister near Stellenbosch in January 2015.
Henry van Breda says he cannot recall if he had seen the axe used in the murders at his home before, but says he cannot dispute that it may have been present. He also said the knife used in the attack on him appeared similar to one which the family had in the kitchen. He demonstrated with a replica axe how an alleged intruder rained blows first on his brother and then his father. He was again asked why he did nothing to help.
But is there some explanation why you didn't defensively try to protect yourselves? Protect your brother, protect each other, try to overpower the intruder?
I think I was just too scared to do anything.
He told the court that police pressed him to give the race of the alleged attacker, but that he had told them he wasn't sure.
It would be strange had a person planned to enter your house and attack the family, that they come armed inadequately or unarmed.
Yes, again, that's logical.
Van Breda refuted evidence of a neighbour who early in the trial testified that she heard raised male voices coming from the Van Breda home, saying that if she did hear that, she would be wrong. Vanessa Pune, SABC News, Cape Town.
In other court cases today, businessman and murder accused Christopher Panayiotis will know today whether he has been found guilty for allegedly orchestrating the murder and abduction of his wife Jade in April 2015. Judge Dayalan Chetty is expected to hand down judgment at the Port Elizabeth High Court. Panayiotis' co-accused Olani Sebeko and Sinatemba Nemembe will also hear their fate. Earlier this week, the court heard closing arguments from both the defense lawyers. In the next hour, we will cross live to the court for more on this story. Two men have appeared briefly in the Mabato Magistrates Court in the Northwest in connection with the murder of local teacher Tulesiwe Ngwenya. Ngwenya was reported missing last week, and her decomposed body was found 3 days later.
Head boy Njokweni and Sfiso Ndawande are allegedly the men behind the murder of Tulisiwe Ngwenya. They are facing 4 charges: kidnapping, murder, rape, and robbery with aggravating circumstances. The pair was arrested in Johannesburg on Monday, allegedly after being found in possession of Ngwenya's cell phone. The NPA says it has more watertight evidence linking the two to the case.
We are confident as the state that we've got a strong case. The reason is that the accused have been linked to the crime through the use of the credit card. This was be able to obtain through the footages that were seen where they're appearing. The identity has been actually been able to identify it through those footages.
The case has been postponed to Thursday to allow the accused to apply for legal representation.
The 45-year-old man accused of raping a domestic worker in Bronkhorstspruit will be back in court today. Now, he faces 3 rape charges, 2 of sexual assault involving dogs, kidnapping and malicious damage to property.
Bronkhorstspruit, edged on the Gauteng-Mpumalanga border. In recent months, several alleged racially motivated incidents. A week ago, this woman shared her harrowing experience with SABC News. She detailed a 12-hour ordeal in which she was repeatedly raped. But her nightmare didn't end there. She claims she was forced to perform sexual acts with 2 dogs.
He forced me into his room and instructed me to undress. I refused. He wanted to beat me and then assaulted his parents. He then blocked his room door with a table and raped me.
This is seemingly not an isolated incident. 2 months ago, this girl, her brother, a friend and their dogs went for a run. The dogs ran into private property and they followed. The owner accosted the girl, accusing her of trespassing. She said she was handcuffed to a tree, assaulted and held at gunpoint.
How can a 9-year-old steal a springbok? Is it possible? That's the reason that they gave. But then what they are saying is that they were not shooting at the kids, they were shooting at the dogs.
The 2 suspects were released on bail of 3,000 rand each. They face attempted murder charges.
Chilean Pillay, SABC News, Johannesburg.
Well, we will take a break shortly and we will be back with more. Stay tuned on the Newsroom.
Sports Live, Saturday and Sundays at 8:30 p.m.
Why is there a dispute over who is the rightful heir to the throne?
What I can say is that Masindi is a woman. She's a girl. She's a girl child. Because I think that if she was a male, there's no way that anybody was going to dispute the fact that she is the rightful heir.
Do you recognize her as your rightful heir?
Yeah, no, I would definitely say that she is my daughter. She grew up there.
What is the intention?
I want my throne.
Join me in Port Zedu live every Monday to Thursday at 17:30.
Welcome back to the Newsroom. You're live on SABC News. Now, a strike at the SABC is underway, with staff belonging to Bamau participating despite ongoing mediation efforts. Negotiations will continue today between SABC management, the Communications Workers Union and the Broadcasting, Electronic Media and Allied Workers Union. The parties met yesterday in an effort to find common ground. The Communication Workers Union said that its members will not be taking part in the strike. Instead, the union wants to give the mediation process a chance. The mediation process involving the SABC board, CWU and BMAU is scheduled to get underway from 9 a.m. However, SABC staff belonging to BMAU have indicated their intentions to go on strike. Both unions are demanding a 10% salary increase, but the SABC has said it can't afford the increases due to its current financial challenges. Meanwhile, prosecutors in New York have filed terror charges against an Uzbekistan immigrant accused of killing 8 people in a truck attack on Tuesday. Now, the FBI, meanwhile, says that they've located a second Uzbeki man wanted for questioning in connection with the attack. The suspect, Sayfullo Saipov, was hospitalized after a police officer shot and arrested him, bringing an end to Tuesday's rampage. He confessed to authorities while in custody that he began planning the attack a year ago. Saipov was charged with 1 count of providing material support and resources to a foreign terrorist organization and 1 count of violence and destruction of a motor vehicle. The 10-page charging document said Saipov waived his rights to remain silent and avoid self-incrimination in agreeing to speak to investigators without an attorney present. New York City police said that Saipov had carried out the attack according to instructions he found posted online by the Islamic State, on whose behalf he claimed to have acted. The U.S. President Donald Trump has called for the suspect to be put to death. Learners who were alleged to have been sexually assaulted by a scholar patroller at a primary school in Soweto here in Johannesburg are being assessed to determine if they could testify in court when the trial begins. More than 50 learners have positively identified the accused as the alleged perpetrator. Now, this emerged in court yesterday, where the 57-year-old accused made a brief appearance.
The state says it's taken statements from 55 of the children, most of whom have implicated the patroller. It was yet another brief court appearance. The 57-year-old man walked into court, his head covered with a jacket. The state says 6 of 7 children who attended an ID parade have positively identified the man as the one who sexually abused them. Another victim, too traumatized to even identify the suspect. Parents say it's affected them psychologically.
My friend went there with her child. She was not right. Even the children were crying. They are very traumatized, especially when they saw this old man.
The Education Department says it's assisting both parents and children.
We're going to have a task team where we have parents' representation and all other stakeholders are there. That's where we agree on what is it that we're going to be doing moving forward. We are making sure that the children are ready to be appearing in court.
The 57-year-old is back in court on the 30th of November. Manqaba Mchunu, SABC News, Soweto.
Eskom bent the rules to help a Gupta-linked company to buy a coal mine. Now, this is what unraveled during the ongoing parliamentary Eskom inquiry. It emerged that Tegeta Exploration and Resources was awarded an advance payment by Eskom that is about 58 times more than the required amount.
It was a day of explosive evidence. A former business rescue expert of the mine lifted a lid on how Tegeta went about to buy a distressed mine from Optimum Mine Holdings last year. The mine was up for sale for just over 2 billion rand, and Tegeta had a shortfall of 600 million. Banks who held the outstanding debt of the mine declined Tegeta a bridging loan to cover the shortfall.
On the 11th of April, we were led to believe by Tegeta that they were 600 million rand short on the purchase price that they needed in order to close the transaction. And the timing of the prepayment was on the very same day, in fact at 9 o'clock in the evening, for an amount relatively similar. So the amount was for 586 million as far as I can remember, And so we believe that the timing of that was something that required further investigation.
Advance payments are common at Eskom to cover pre-production costs, but the committee heard that in this instance, the payment covered Tegeta's shortfall. In fact, pre-production costs like equipment were 58 times less than the advance payment. Marsden says he laid charges with the Hawks in July last year, but claims the progress of the probe had been disappointingly slow. The inquiry wants monies to be recovered.
How can we get those monies back? Because they belong to the community of South Africa. They belong to the poor people.
The implications is on ordinary people who are now going to be forced to pay 20% more for electricity because of the mismanagement of Eskom.
It also emerged that it was the auditing firm KPMG that facilitated the purchase of the mine on behalf of Tegeta. Pulelani Philip, SABC News, Parliament.
Now, South Africa has become fertile ground for many illicit fake doctors with either non-existent medical credentials or highly exaggerated ones, so as to get more attention, money, and even fame from unsuspecting patients. The country's economic hub of Johannesburg has been the hardest hit with the presence of bogus doctors. That goes with the increase and influx of foreign nationals. Most of these doctors have started their practices in dodgy parts of Johannesburg like the Joburg CBD, Hillbrow and Newtown. The Hawks, the National Traffic Anti-Corruption Unit, as well as the Health Professional Council of South Africa, have raided premises of suspected illegal or fake doctors in the Johannesburg CBD. The Minister of Health, Dr. Aaron Motsoaledi, joined us to talk about the problem that is facing South Africa and the growing number of bogus or fake doctors.
It's extremely frustrating because the number is growing and causing a big problem. These are the people I generally will refer to as quacks. As long ago, as 30 years ago, when I was still a general practitioner, we had to deal with this issue of quacks in my home province of Limpopo, when it was still called Northeastern Transvaal, together with Mpumalanga. We had a doctors' organizations called NAMDA, National Medical and Dental Association, where we had to identify a few of these quacks, people who are said to be practicing medicine who we knew have never been to any medical school. We sent their names to then South African Medical and Dental Council, and the answer came very simple, that we only work with registered doctors. We cannot deal with anybody who's not registered, so you don't know them. So eventually it becomes a police case because these basically are criminals. As you know, Elvis, many of them put stickers all around and say safe abortion, quick abortion, cheap abortion, and put a cell number there and the name of a supposed doctor. None of those are doctors. They are all thugs. They are criminals. And if we find them, we have got to refer them to police. But they work like ghosts because you'll never find them. You can phone that number. They might respond to you. You'll never even find the location where they are working from.
Now, some of these fake doctors, Minister, we believe are operating from premises of previously legal known practitioners, and they were registered. So how does this then happen that they basically take over the practice and invade the practice of a legal practitioner?
Well, the problem, Elvis, which we still have to deal with as a country, is that to be a private practitioner, all you need is to open your practice and go to the Board of Healthcare Funders, ask for a practice number in order to claim from medical aid. In other words, it's easier to start the practice than to start a petrol station in the country, because you don't need to be licensed. You only need the practice number, then you can practice everywhere. Now, people who are quacks do not have practice numbers, which means they can't claim from medical aids, but they can demand cash from you. And Elvis, because in the African continent, medicine has been mystified. Anybody who practices something that is mysterious is likely to attract clients. It's like the religious sector. You are aware that there's been a commission about it, because we have got many quack prophets around, but they've got a huge following because they are doing so-called mysterious things. So the general public loves somebody who does not practice pure science, but is doing some mysterious things, and they believe that person has got power. That's very unfortunate.
Now, it seems many of these practices, these bogus doctors, are operating from private practices. Is there perhaps a signal from your department that they have managed to infiltrate the public space as well?
Look, as I have said, even qualified doctors who work in their practices, the only thing they need to do is to produce their certificate to the Board of Healthcare Funders. That gives them what is called a practice number. Each doctor in each hospital has got a practice number which they code when they claim from medical aids. As to where you practice is your own choice. Now, these quacks, all they have to do is not to obtain practice numbers, which means they can't claim from medical aid, but they can claim cash from you. If you go to them, and as I'm saying, many people like going to quacks because they try to practice mysterious things which attract the public. So from our side, we are going to try and push the Health Professions Council to have some inspectors who move around. But as I'm telling you, the weakness of the Health Professions Council, as I discovered even 30 years ago, long before democracy, is that they will tell you that in terms of the law, they deal only with registered practitioners. That means if you go to report a registered practitioner for doing something unethical, they say we have got jurisdiction over such a person. But any quack who is from the street, who is not registered with the Health Professions Council, either as a doctor or as allied health professional, etc., they will tell you we have got nothing to do with such a person. It doesn't fall within our purview, which means then, Elvis, all these things are police cases, but you know that police are inundated with lots of crimes. It's very difficult for them to move around, sniffing around quack doctors. So we just have to go out and educate the public and maybe try to empower the Health Professions Council or the Department of Health to have some inspectors or some spies, if I may put that way, if I may put that, and who must sniff around. I believe maybe we can start training our community health workers to start doing that work of helping us to identify the quacks, because they are definitely destroying the healthcare system.
Now, the Hawks, as well as RTMC and other members, have raided some of these quacks, the practices in Johannesburg. One of them, Minister, has been operating for more than 10 years without being detected. Do we have the adequate control mechanism to check out who is who, such as this doctor that has been caught nabbed and, of course, issuing fake PDPs to drivers?
Elvis, these are thugs. Thugs are to be found anywhere. These are the fraudsters and thugs. In the medical field, we have got thugs, as you do have in the financial field, in the construction field, in the legal field. I'm sure you are aware that in every field in our country, there are quacks and fraudsters. And so the medical field is no different. So all we have to do, as I'm saying, is to work with police to try our best to try and get all these fraudsters. But they are found in all spheres of our lives.
Mm-hmm. What are the implications for these bogus doctors, or quacks as you call them, Minister?
The implications in what way, Elvis?
If they are being caught as practicing bogus practices and so on?
As I'm saying, they have to be dealt with by the criminal legal system in our country, because it's criminality. There's no other way of dealing with it. For instance, as I've already said, the Department of Health cannot prosecute them in terms of the Health Professions Council Act or the Nursing Act or the Pharmacy Act or all the acts where we register our professionals, because they are not registered. So they must be dealt with any thug who defrauded the bank, who pretended to be a lawyer, who pretended to be a teacher, who pretended to be an engineer, etc., etc.
Mm-hmm. And the implications on the health sector, Minister, does it have any impact?
It does have an impact, Elvis, a huge one. I've just outlined to you that they put posters all over advertising abortion. I was asked by members of parliament one day, why am I allowing doctors to advertise abortion? I said, no, doctors are not doing that. They then showed me some stickers which they took around, which are all over, stuck in all public places, written quick abortion, safe abortion, cheap abortion, Dr. John or Dr. Johannes, and they put a phone number there. And they said, here, it's written doctor. I said, no, but they are criminals. They are not doctors at all. They are criminals like any other criminal practicing a crime. And they do cause problems, Elvis, because they induce abortions, and these young girls come into the health system to drop the baby dead there, and it becomes our problem. When that baby dies in a hospital, it's regarded as our own mortality, that we are not able to treat people, when actually it's a criminal who induced that thing in some corner which we cannot even, which we don't even know about. And some of these young girls, of course, they don't come on time. They come with septic abortion. Some come to die. Some we have to take their uteruses out. We have to do a hysterectomy. Can you imagine an 18-year-old girl losing a uterus because she came to a hospital with a septic uterus which she can't save because it was started by a quack somewhere?
Absolutely shocking, I tell you. That was the Minister of Health, Aaron Motsoaledi, talking to us about the issues of fake or bogus doctors. And the question is, have you been affected by some of these fake or bogus doctors in your area where you live? Now, we know that it's very prevalent here in Johannesburg. What about Cape Town, Durban, Port Elizabeth, or wherever you live? Is there a problem like that? Well, you can let us know on the Twitter handle at SABC Newsroom as well as on the Facebook page. Meanwhile, the Economic Freedom Fighters, the EFF, is planning to march to the Israeli embassy in Pretoria today. Now, this is in protest against the Balfour Declaration of 1917 that was issued by the British government during the First World War. Now, it supported the establishment of a national home for the Jewish people in Palestine. The EFF is calling for the isolation of the Israeli government over the occupation of Palestine.
It's been 100 years since the signing of the Balfour Declaration, a document that supported the establishment of a national home for the Jewish people. Now, as the world prepares to celebrate the centenary of the declaration, the EFF says there's nothing to celebrate as Palestinians live under difficult conditions. They will march to the Israeli embassy in Pretoria to support calls for Israeli government to give Palestine its full independence.
This is an intensification of the call for boycotts, divestments and sanctions that has been made in 2005 by the Palestinian civil society. By the way, this society or the Palestinians through this call, they are not asking us for bullets. They are not asking us for nuclear arms. They are not even asking us for us to support them through military help. It's a non-violent struggle to isolate Israel in the academy, to isolate them politically in terms of diplomatic relations, in terms of consumer boycotts, in terms of business boycotts, in terms of sports boycotts, in terms of cultural boycotts, in music, in the arts. Let us isolate the government of Israel to put it under pressure so that it gives freedom to the Palestinian people.
The South African Jewish Board of Deputies says instead of fighting for the isolation of Israel, the EFF should try and facilitate dialogue.
I really think that the best thing for people to do, and the message that the EFF should be bringing, is that as South Africans we should be contributing to peace and to dialogue and to helping the parties in that area of the world come to a peaceful agreement, just like we did as South Africans.
The march is expected to start at Church Square, Pretoria at 11 o'clock. Ntlantla Khatlani, SABC News, Johannesburg.
To get the latest now, we cross live to our reporter Ntakwana Ngatane, who is at the EFF march, for an update on the story. Very good morning to you, Ntakwana. Ntakwana, can you hear me? Well, we're trying to get hold of our reporter there on the ground, Ntakwana. Can you maybe just give us an update there, if you can hear me, Ntakwana? What is happening with the current march?
Yes.
Well, It seems like we're not getting hold of her. We're going to try and get her for you to give us the latest coming live from Pretoria. Now, businessman and murder accused Christopher Panayiotis will know today whether he has been found guilty for allegedly orchestrating the murder and abduction of his wife Jade in April 2015. Well, we're going to see if we can also get that link and go live there in a short while. Let's see if we can get it live. Yes, it seems like we're up and running.
Vital information from the South African Police Service regarding his contact with Lutando Sione, and in so doing, accused number one did defeat or obstruct the course of justice. The accused pleaded not guilty to the various counts. In amplification of his plea, accused number one tendered a prolix document incorporating not only his defences to the charges, but his assessment of the state's anticipated testimony, hearsay, extracts from the case docket, a judgment, Police Standing Order 252, and a collection of photographs of Mr. Lutando Sione, the central figure of his plea in limine, which he articulated thus, and I quote, "I will request this Honourable Court to order a trial within a trial on the basis that the evidence obtained following the removal of state witness Lutando Sione from Infinity Pub and Grub at approximately 2015 on Monday 27 April 2015 is inadmissible. All the evidence following his removal and thereafter is tainted as the result of the police assaulting, intimidating and unlawfully pressurizing Ellis to implicate me. Therefore, the evidence obtained against me was unlawfully and unconstitutionally obtained by the state, with the result that my right to a fair trial has been violated." Close quotations. His plea on the merits was enumerated as follows: I deny the allegations that the state has made against me. I deny specifically ever approaching Ellis and requesting / ordering / asking him to find a hitman / hitmen to have my wife, the deceased, Jade Panayiotis, killed. Jade and I had been married for just over 2 years at that point in time, and as far as I was concerned, we were happily married. I loved my wife Jade, and in February 2015, we made a decision to buy a house in Lovemore Park for approximately 2.2 million, in which we were going to move in together and hopefully spend the rest of our lives therein. By the time this incident occurred, the necessary bond fees and deposit has already been paid, and it was just a matter of the two of us moving in. Prologue. Jade and accused number one were married to each other and resided in a gated townhouse complex situated at 19 Stellan Glen, Deacon Road, Kabiga Park, Port Elizabeth. He was and is a businessman, and she, during her lifetime, a junior teacher at Rivier College Girls High School in Uitenhage. Jade and her colleague, Ms. Cherise Taylor Swanepoel, Ms. Swanepoel, were accustomed to travel together by Uitenhage each day by car, alternating between the usage of their respective motor vehicles weekly. Ms. Swanepoel lived at 25 Ruth Street, Glenherd, and each would be collected from their respective homes by the other. To facilitate Jade's pickup, Ms. Swanepoel was accustomed to send her a text message when leaving her home and then collect her at the gate of the complex. This was the scheduled arrangement, except that on 21 April 2015, Ms. Swanepoel had texted Jade to inquire whether, by reason of the inclement weather, she should not drive into the complex and collect her from her home. The reply received was that she would walk to the gate. On Ms. Swanepoel's arrival at the entrance, however, there was no sign of Jade, and her text message to announce her arrival went unanswered. The uncontroverted evidence is that the message was sent at 06:33. Perplexed thereby, Ms. Swanepoel dialed Jade's landline, but it too went unanswered. Sensing that something was amiss, she telephoned accused number one on his cell phone, and when he answered, inquired about Jade's whereabouts. His riposte was that she had gone to work. The upshot of the conversation was that accused number one opened the automated gate to let Ms. Swanepoel in. It is furthermore common cause that accused number 1 in Ms. Swanepoel drove out of the complex and along its periphery to look for Jade, but to no avail. Fortuitously, they encountered a police vehicle along the way, and thus began the search for Jade. A number of people, including accused number 1, participated in the hunt for Jade in various locations within Port Elizabeth, Uitenhage and its environs that day. She, however, remained unaccounted for. Having widened the parameters of the search area the next day, a police tracking unit discovered her body later that morning on an open field close to a gravel road which dissects Wincanton Road on the outskirts of Uitenhage. The area was secured and a police forensic unit dispatched to the scene. The events which unfolded subsequent to Jade's discovery was narrated by a number of witnesses. What follows is a précis and, where necessary, an appraisal of their testimony. Dr. Kevin Fourie, the head of the clinical unit, Forensic Pathology Services, conducted a post-mortem examination on the cadaver on 23 April 2015 and concluded that the cause of death to be consistent with bullet wounds to the head and chest. His chief post-mortem findings were recorded on the medical post-mortem report, Exhibit L, as follows: perforating bullet wound to the skull and brain, perforating bullet wound of the chest involving the left lung, perforating bullet wound of the chest involving the spinal column, spinal cord and the right lung. This wound track can be aligned to a bullet track through the right upper limb, bilateral hemothorax. He recorded the external appearance of the body and the conditions of the limbs as: 1. There is a 8 mm circular penetrating lacerating wound with a 2 mm collar of abrasion, more prominent infero-laterally over the left lateral head, 13 cm from the top and 3.5 cm from the tragus of the left ear. There is a 1.5 cm by 2 cm stellate penetrating laceration wound with everted wound edges over the right parieto-occipital region, 5 cm from the top of the head. 3. Bilateral periorbital hematomas. 4. There is a 7 mm circular penetrating lacerating wound with a 2 mm collar of abrasion over the left posterior chest, 14 cm from the midline and 10 cm below the shoulder line. 5. There is a 1.5 cm by 7 mm irregular penetrating lacerated wound over the left anterior chest, 5 cm from midline, 11 cm below the shoulder line. 6. There is a 6 mm circular penetrating wound with a wide 5 mm crescent of abrasion laterally over the left posterior chest, 4 cm from the midline and 11 cm from the shoulder line. 7. There is a 20 mm by 10 mm gaping penetrating lacerated wound in the right mid-axillary line, 2 cm below the axilla. 8. There is a 15 mm by 9 mm penetrating lacerated wound with a wide collar abrasion of the left upper limb anteriorly, 18 cm below the right elbow. There is some confluent contusion of the right upper limb associated with this wound. 9. There is a 14 mm by 11 mm irregular penetrating lacerated wound with everted wound edges over the right upper limb posteriorly, 12 cm above the right elbow. 10. There is a 6 mm laceration over the right finger at the second interphalangeal joint. 11. There is a 5 mm laceration over the base of the right thumb, anteriorly at the wrist. 12. There is a 3 mm abrasion over the right wrist, posteriorly, 26 cm below the elbow. And 13. There are no ligature impression marks around the wrists or ankles. Captain Gideon Olivier, a ballistic expert attached to the Forensic Services Laboratory, attended the scene prior to the removal of the cadaver on 22 April 2015 and again before the post-mortem examination on the 23rd of April 2015. On the former occasion, he retrieved 3 cartridge cases and on the latter unearthed a spent bullet embedded in the ground directly below where he had observed the deceased's head. From his observations at the scene, the post-mortem examinations and the pathologist's findings, he concluded that the first shot fired at Jade entered her back and exited her chest. The second, that which lacerated the spinal cord and paralyzed her from the waist down, and the third, the shot to the head. Olivier opined that given the trajectory of the latter bullet track, the shooter would have been standing on her left-hand side with his arm outstretched, pointed in the direction of her head when he fired. It is common cause that gunpowder residue was discovered on the deceased's hand, and the inference can thus properly be made that in her final moments, Jade's outstretched hand entreated mercy. That act of supplication, however, elicited a bullet to her head. The medical and ballistic findings compelled the conclusion that this was an execution-style murder. The discovery of Jade's body and confirmation that she had been murdered reverberated far and wide and evoked a media frenzy. Brigadier Gary Dale McLaren, the provincial head of the East Cape Detective Services based in East London, recounted being contacted by an informant on the Wednesday following the discovery of Jade's body. Although he could not recall the exact date, it is clear that it was the very day upon which Jade was discovered. He duly interviewed his snitch and, accompanied by Colonel Rowan, left East London and proceeded to Cornubushle on further investigation prior to returning to East London. Fortified by the intelligence gathered, he returned to Port Elizabeth the same afternoon, where he met with members of the Directorate for Priority Crime Investigation, the DPCI, and established a task team under the leadership of Captain Reinhard Swanepoel to spearhead the investigation. The breakthrough in unmasking key figures to assist in the investigation occurred on Monday, 27 April 2015, when Captain Willie Mai, the head of the Vehicle Hijacking Division of the South African Police Services in Port Elizabeth, received a call from an informant. It is not an issue that Mai was on investigative duties in Alice when he received the call. He hastened to Port Elizabeth to meet with his informer. This meeting provided the impetus for Mai to search for Sione at his gym, and when he could not be located there, to the home of his girlfriend Bababa Breakfast, and thence to the Infinity Club. Sione's involvement in the conspiracy to murder Jade was extensively expounded upon in the summary of substantial facts, which, juxtaposed alongside the plea explanation, established that he is, paradoxically, the nucleus of accused number one's defense and a key witness for the state. Given his centrality to accused number one's defense, it is apposite to consider the legitimacy of the quest to have his testimony determined as a separate issue, colloquially referred to as a trial within a trial. The contention that it be so determined was vigorously pursued by both Mr. Price and Mr. Doberman in argument before me. I interpolate to say that although counsel for the state was initially seduced by the superficial attractiveness of the proposed course, overnight deliberation exposed its flaws, and he opposed the application. As I shall elaborate upon, it is unprecedented, an exercise in opportunism, and a disingenuous attempt to exclude otherwise admissible testimony. I dismissed the application and indicated that my reasons would be incorporated in the judgment, and these now follow. A trial within a trial is, as Stryker J. trenchantly alluded to in Director of Public Prosecutions v. Transvaal v. Viljoen, a trial held while the main trial is in progress in order to determine a factual issue separately from the main issue. The factual issues contended for by the defence was the voluntariness of Sioni's testimony, inclusive of his extracurrial statements and pointings out to various officers. The gravamen of their attack on its admissibility is the contention that Sioni's fundamental rights were violated to such an extent that all the evidence consequentially procured is inadmissible against the accused. Leaving aside for a moment the question whether Sioni was in fact tortured as alleged, a matter I shall in due course consider, the fallacy of the argument advanced is the conflation of Sioni and an accused person. Sioni is, notwithstanding his designation as such by both Messrs. Price and Doberman, not an accused person. He is a state witness, whom counsel for the state intimated when called to the witness stand that he be warned pursuant to the provisions of Section 204 of the Criminal Procedure Act. In his address, counsel for accused number 1 was, given the excogitated nature of the application, constrained to concede that the absence of any authority for the submissions advanced. The raison d'etre for the dearth thereof is evidence. It is a procedural device available only to an accused person and no other. A succinct exposition of its genealogy was articulated by Nicholas A.J.A. in A State v. De Vries, 1989, 1 essay 228A at 2328 to 234A as follows. Section 2171 of the Criminal Procedure Act 51 of 1977 provides for the admissibility of evidence of a confession made by any person in relation to the commission of any offence if such confession is proved to have been freely and voluntarily made by such person in his sound and sober senses and without having been unduly influenced thereto. There had been similar provisions in Section 2731 of the Criminal Procedure Evidence Act 1917 and in Act 56 of 1955. In R v. Gumedi and another, 1942 AD 398-412-413, Freetham J. mentioned that the provision first appeared in South African legislation as part of Section 28 of the Cape Ordinance 72 of 1830 and added, there can, I think, be no doubt that the proviso was included in the 1830 Ordinance was intended to apply to the Cape Colony, the common law of England as then understood, in regard to the burden of proof resting on the prosecution when asking a criminal court to admit a confession alleged to have been made by an accused person. The rule of the English common law had by 1830 become well established and was of long standing. See Gumedi's case supra at 413 in Finn. It was described by Innes C.J. in R.V. Barlin, 1926 AD 459 at 462 as, the common law allows no statement by an accused person to be given in evidence against himself unless it is shown by the prosecution to have been freely and voluntarily made in the sense that it has not been induced by any threat or promise proceeding from a person in authority. The rule is a rule of policy. In Gumedi's case supra at 413, Freetham J.A. quoted from the judgment of Lord Sumner in Ibrahim v. R. 1914 AC 599 at 610, a confession forced from the mind by the flattery of hope or by the torture of fears comes in so questionable a shape that when it is to be considered as evidence of guilt that no credit ought to be given to it. Rex v. Warwickshire, 1873, 1 Leach 263. It is not that the law presumes such statements to be untrue, but from the danger of receiving such evidence, judges have thought it better to reject it for the due administration of justice. If the policy is to be effectuated, it is of primary importance that an accused person should feel completely free to give evidence of any improper methods by which he alleges a confession or admission has been extracted from him. Unless he gives evidence himself, he can rarely challenge its admissibility. See the judgment of Lord Hailsham in St. Mary Lebone in the Privy Council case of R.V. Wong Kam, 1980 AC 247 PC or 261B to C. Any civilized system of criminal jurisprudence must accord to the judiciary some means of excluding confessions or admissions obtained by improper methods. This is not only because of the potential unreliability of such statements, but also, and perhaps mainly, because in a civilized society, it is vital that persons in custody or charged with offences should not be subjected to ill treatment or improper pressure in order to extract confessions. It is therefore of very great importance that the courts should continue to insist that before extrajudicial statements can be admitted in evidence, the prosecution must be made to prove beyond reasonable doubt that the statement was not obtained in a manner which should be reprobated and was therefore, in the truest sense, voluntary. For this reason, it is necessary that a defendant should be able and feel free, either by his own testimony or by other means, to challenge the voluntary character of the tendered statement. It is accordingly essential that the issue of voluntariness should be kept clearly distinct from the issue of guilt. This is achieved by insulating the inquiry into voluntariness in a separate compartment from the main trial. In England, the inquiry into voluntariness is made at a trial on the voir dire, or simply the voir dire, which is held in the absence of the jury. In South Africa, it is made at a so-called trial within a trial. Where, therefore, the question of admissibility of a confession is clearly raised, an accused person has the right to have that question tried as a separate and distinct issue. At such trial, the accused can go into the witness box on the issue of voluntariness without being exposed to general cross-examination on the issue of his guilt. The prosecution may not, as part of its case on the main issue, lead evidence regarding the testimony given by a defendant at the trial. It will be gleaned from the aforegoing, and in particular the highlighted portion of the quoted judgment, that the procedure is available only to an accused person. Sione is, despite assiduous clamour by the defence representatives, not an accused person. The fact that he had been arrested and initially charged with Jade's murder is entirely irrelevant. He is a state witness, cadet quaestor. Dismissive of my ruling that the proposed procedure was ill-conceived, Mr. Doberman nonetheless launched a fresh application the following morning, contending that authority vouchsafed the granting of the application. Neither the cases nor the journal article cited established the principle contended for, and I dismissed the renewed application. The attempt to persuade me to revisit my earlier ruling was misguided and to be deprecated. The rationale for the concerted endeavour to exclude Sione's testimony from the conspectus of evidential material soon manifested itself. As presaged in the summary of substantial facts, the state's case was that Sione was intimately involved in securing the assassin, and it was evident from the factual matrix encapsulated therein that it constituted inter alia a précis of his statement or statements to the police. Its acceptance prima facie heralded dire consequences for the accused, and in particular accused number one, and the stratagem devised for its exclusion obviously required his collusion. The full extent of his connivance soon manifested itself, as I shall advert to hereafter. It is abundantly clear, notwithstanding the gratuitous imputations levelled against Mr. Stander, that the latter had been deceived into believing that he would adhere to the content of his statements to the investigating officer Swanepoel. This appears clearly from the concluding email from his attorney, Mr. Neza, to Stander on 4 October 2016. The aforementioned email and a raft of earlier missives was introduced into the trial by Mr. Price during his ostensible cross-examination of Sione. Although it is permissible to put leading questions during cross-examination, no weight whatsoever can be attached to any of Sioni's affirmative responses. The cosseted questioning, designed to establish that Sioni was not the author of the content of the statements to Swanepoel, which bore his signature, and his acquiescence in the insinuation that counsel for the state had, notwithstanding knowingly called him, established the extent of Sioni's collusion with accused number 1. As for Neza, the least said about him the better. His advice to Sioni that he should not answer any incriminating questions is in direct conflict with legal precedent. As Ackerman J. remarked in Nell v. LaRue, Eno and others, and I quote, in view of the transactional indemnity and use immunity provisions in Section 204, 2 and 4 of the Criminal Procedure Act, the applicant could not validly and did not object to answering self-incriminating questions. It is apparent from the last email from Neza to counsel for the state, 4 October 2016, wherein he stated, and I quote, "Our client remains a Section 204 witness and does not have any intention to deviate from such unless your office reject him as such," close quotation, that Mr. Stander was thereby duped into believing that Sioni would testify in conformity with the version chronicled in his statements. Subsequent events soon established the extent of the collusion not only between himself, Breakfast, and those family members called to corroborate his version, but it moreover compels the conclusion that Neza was party to the deception practiced on the prosecution. It is common cause that in consequence of information obtained, Mai, after a fruitless search for Sioni at his home, and Jim departed to Breakfast's home where, after interviewing her, she accompanied him and directed him to Infinity, where Sioni was taken into questioning prior to them being taken to the Kwanebugre detective officers. Although Breakfast would later decry having deposed to written statements to Mai, her denial is patently false. Her revelations to Mai validated the information obtained from his snitch, and I accept that when later confronted therewith, Sioni admitted his complicity in the conspiracy to murder Jade. Mai's evidence concerning the amiable interaction between himself, Breakfast, and Sioni required remedial action to conform with the version advanced by accused number 1 in his plea explanation, and Breakfast's cross-examination by Mr. Price was thus structured to achieve that result, as appears from the following extract from the transcript, and I quote, "On the 27th of April, when the police came to your house, that was Captain Mai and other police officers correct? That is correct, sir. And you have told us that it was decided that one of your brothers will go with you, and if I understand you correctly, it was to ensure that you were okay, that you were safe. That is correct, sir. And can I accept that you wouldn't have been comfortable to go with these police officers if your brother wasn't allowed to go with you? Yes, my lord, because those people were unknown to me, and I saw them for the first time that evening. Now, my understanding of your evidence is that you weren't asked to accompany them, you were ordered to accompany them. They came in, they said they were looking for Babawa. Pardon. Yes, listen carefully. I'm not fighting with you, just listen carefully. I'm saying to you, they didn't ask you nicely if you would go with them. They told you, come with us. My mother responded to them, and then I got up. Yes, I don't think you are listening to me. Would you have gone if they hadn't told you to go with them? Let me ask you that. No, my lord. You felt you were obliged to go with them because they said they wanted to ask me some questions. Listen carefully, listen carefully. You went because you didn't go because you wanted to go. You went because they told you to go. Yes, my lord. It will be gleaned from the aforegoing that the assertions made to Breakfast, and which were subsequently put as a fact to Mai, did not emanate from Breakfast at all. Her acquiescence in the propositions put to her by Mr. Price, clearly establishes her partisanship and compels the conclusion that she had been suborned to recount her police statements. As adverted to in the preceding paragraphs, during Mai's cross-examination, this erroneous rendition of the true facts was perdured with by the following proposition put by Mr. Price. So you will not dispute her evidence in this court that she feared you and your group, and it was a decision to take her brother with so that he could look after her best interests. And later, now could you just explain to me why you took Babalwa's brother back to the house before you went to Corroborating? There was no reason. I just took him back home because we found Tando home. We went to look for him at Algoa Park. Yes, but Babalwa was going to show you where Tando was. Why did you take her brother back? Her brother had nothing to do with this at all. Of course, except he might have been a witness to you beating people up and threatening people. That is why he was taken back. No, I don't think so. If we were aware that we would also require a statement from him, we would have taken him along, but because he had nothing to do with the case at that stage, that is why he was dropped off at his home. Well, Babalwa told this court that she wanted him there as protection for herself and that she was unhappy when you dropped him back at home. She wanted him to go with them to wherever you were going. I hear this for the first time here in court because she never ever requested her brother to be taken along to Corroborating or display any discontent by the fact that he was dropped off at home. It was your decision to drop him off. That is correct, sir. I did inform Babalwa that we are going to drop off your brother now. It became clear during breakfast evidence in chief that she had recanted her police statement, a fact confirmed by counsel for the state. Thus, as a precursor to requesting that she be declared hostile, Mr. Stander, having established that her signature was indeed appended to each of the police statements, Exhibits V25 and V26, proceeded to question her therein. In response to a question as to the circumstances under which she signed the statements, she proffered the answer that she was merely given a piece of paper to sign and duly complied with the instruction. To prove that she was indeed the author of the statement, Mr. Stander proceeded to read the statement to her to elicit her confirmation. The regurgitation of the statement, sentence by sentence, yielded the stock answer that its content did not emanate from her. I interpolate to say that Mai was subsequently called to testify that he minuted both statements which she signed in his presence. The procedure adopted by Mr. Stander finds legislative sanction in Section 190 of the Criminal Procedure Act. It provides as follows. 190. Impeachment or support of credibility of witness. 1. Any party may in criminal proceedings impeach or support the credibility of any witness called against or by or on behalf of such party in any manner in which and by any evidence by which the credibility of such witness might on the 13th day of May 1961 have been impeached or supported by such party. 2. Any such party who has called a witness, who has given evidence in any such proceedings, bracket, whether that witness is or is not, in the opinion of the court, adverse to the party calling him, close bracket, may, after such party or the court, has asked the witness whether he did or did not previously make a statement with which his evidence in the said proceedings is inconsistent, and after sufficient particulars of the alleged previous statement to designate the occasion when it was made have been given to the witness, prove that he previously made a statement in which such evidence is inconsistent. When counsel for the state solicited the details surrounding the money found in Sioni's gym bag and which were encapsulated in Exhibit V25, it triggered a marked attitudinal change in breakfast and, as the further questioning unfolded, her demeanor indicated open hostility towards the prosecution. The inference can thus properly be made that she had misled counsel for the state into believing that she would testify in conformity with her police statements, Her deception, attitude and behavior demonstrated her implacability, and a declaration of hostility seemed meet. I interpolate to say that the objection raised by Mr. Doberman to my declaration is without any merit whatsoever and requires no further elucidation. Under cross-examination by Mr. Stander, it became abundantly clear that her denial of being the author of the statement's contents is patently false. I accept that she was the source of the information recorded in Exhibits V25 and V26. I shall in due course, in conjunction with Sioni's extracurrial statement, determine their probative value, but proceed first to the aftermath of her revelations to Mai. It is not an issue that Sioni was interrogated at the Corner Bushley detective offices by Mai. In his evidence in chief, Sioni described the assault perpetrated upon him by Mai and a number of other policemen as, and I quote, torture. It is unnecessary to delineate the nature and extent of the alleged battering for the simple reason that his evidence is, upon a holistic appraisal of the evidence, a cocktail of lies, perjury and contrivances designed to advance accused number one's defense. While it is correct that Sioni's eye was swollen, I accept Mai's testimony that the injury was sustained during the scuffle when Sioni resisted being handcuffed. It is highly improbable, given the unprecedented outcry and media frenzy which accompanied Jade's murder, that Mai or any other member of the initial investigation team would have been so foolhardy to jeopardize the investigation by perpetrating an assault on Sioni, particularly in light of the revelations by Breakfast of his direct involvement. The probabilities favor Mai's version that after being confronted with Breakfast's revelations, Sioni admitted his complicity in Jade's murder and directed the police to various places where the money was eventually retrieved. In his address, Mr. Price submitted that Sergeant Nedi Gukamana did not support Mai's version and that an adverse inference should be drawn from the failure to call the policemen who were present on the night in question. That fact that Gukamana was unable to recall having heard Sioni consenting to point out the money does not avail the defense. The import of his evidence fully corroborates Mai's, and there was accordingly no need for the state to call supererogatory witnesses. The fact that he thereafter exclaimed having been assaulted amounts to sheer opportunism and merely establishes his guile. The injury provided the visible manifestation of his claim and was a mechanism whereby he could subsequently impugn Mai's credibility and seek to avoid the consequences of his admissions to him. A classic example of his penchant to prevaricate and lie occurred when questioned about the money found in his gym bag later that evening. It elicited a convoluted, prolix explanation that it was money entrusted to accused number one for safekeeping, which he had retrieved to recompense Sizwake Zumazonke, who had sourced weights for his gym. That account of its derivation corresponded in broad outline with Breakfast's viva voce explanation tendered prior to her being discredited, and remarkably also broadly conforms to accused number one's plea explanation as to its source. At the conclusion of the hearing on that day, i.e. Friday, 11 November 2016, that remained his version. Sioni's weekend sojourn at the awaiting trial cells had a profound effect on his powers of recollection. When he was recalled to the witness stand on Monday morning, 14 November 2016, he made a complete volte-face and stated that the money was the pilfered portion of the 80,000 rand he had received from accused number one destined to Vomazonke as payment for Jade's contract killing. This veracious account of the source of the 31,000 rand accords with Breakfast's narrative in her police statements V25 and V26, albeit that she had not on her version counted the money which she placed in the socks. Arithmetically, it amounted to 31,000 rand. As I shall in due course further detail, Sioni's evidence is, with one exception, i.e. the 80,000 rand, fabricated and false to be rejected. His malleability was most pronounced during his ostensible cross-examination by Mr. Price. Having been suborned to recant his extracurricular statements, his acquiescence in the plethora of leading questions put to him accentuates the deception whereby he inveigled the prosecution into calling him as a witness. This is best illustrated when, after being cajoled into validating Breakfast's claim to blindness, he readily assented to a multitude of propositions inter alia that he had not only been assaulted, browbeaten into submission, forced to accompany the police to search his home and the place where the 31,000 rand was recovered, ill-treated, but forced to append his signature to prepared statements. Whilst it is correct that the right of full cross-examination includes the employment of leading questions, the weight of the evidence thus procured is minimal where, as here, Sioni's partisanship is glaring. I accept that the true account of what transpired between accused number 1 and Sioni is the version encapsulated in the statement Exhibit AY1, which he deposed to Swanepoel on 3 May 2015. The same considerations apply to Breakfast's statements to Mai on the evening of 27 April 2015. Notwithstanding the fact that the content of Exhibit AY1 was extensively covered with Sioni when cross-examined by Mr. Stander, and the document handed in as an exhibit, an objection was raised when a portion of its content was canvassed with Ms. Chanel Kutz during her cross-examination. The contention that the statement has not been proved is spurious. When Swanepoel was led, he detailed the circumstances which led to him minuting the statement, adverted to the meeting between Sioni's then attorney Van der Spey and the eventual signing of the statement by Sioni. Swanepoel's evidence that Sioni appended his signature to AY1 proves that he made it. The question whether the contents of the aforementioned statements, which, as I have adverted to, were disavowed by both Sioni and Breakfast when they were called to testify, constitute admissible evidence, has received the imprimatur of the Supreme Court of Appeal in State v. Latumba, 2012, 2 SACR 219 SCA at para 10. Such evidence is, as the Court correctly categorized, hearsay evidence. Its reception is regulated by Section 3.1 of the Law of Evidence Amendment Act, which provides as follows. 1. Subject to the provisions of any other law, hearsay evidence shall not be admitted as evidence at criminal or civil proceedings unless a. Each party against whom such evidence is to be adduced agrees to the admission thereof as evidence at such proceedings, b. The person upon whose credibility the probative value of such evidence depends himself testifies at such proceedings, or c. The court having regard to 1. The nature of the proceedings, 2. The nature of the evidence, 3. The purpose for which the evidence is tendered, 4. The probative value of the evidence, 5. The reason why the evidence is not given by the person upon whose credibility the probative value of such evidence depends, 6. Any prejudice to any party which the admission of such evidence might entail, 7. Any other factor which should, in the opinion of a court, be taken into account is of the opinion that such evidence should be admitted in the interests of justice. In holding that the evidence of the witnesses who had disavowed their police statements had been properly admitted in evidence by the trial court, the Court of Appeal reasoned as follows, and I quote, Section 3 enjoins a court in determining whether it is in the interests of justice to admit hearsay evidence, to have regard to every factor that should be taken into account, and more specifically to have regard to the factors mentioned in Section 3.1c. This court in State v. Ndlovu and others, 2002 SACR 325, SC8, who considered the provision of Section 3 and at paragraph 31 held, and I quote, "The probative value of the hearsay evidence depends primarily on the credibility of the declarant at the time of the declaration, and the central question is whether the interests of justice require that the prior statement be admitted, notwithstanding its later disavowal or non-affirmation. And though a witness's disavowal of or inability to affirm the prior statement may bear on the question of the statement's reliability at the time it was made, it does not change the nature of the essential inquiry, which is whether the interests of justice require its admission." In amplification, in paragraph 33, it was stated that the probative value of the accused statements to the police did not depend on their credibility at the time of the trial, which the court rightly found totally lacking, but on their credibility at the time of their arrest. And the admissibility of those statements depended not on the happenstance of whether they chose to testify, but on the interests of justice. This is precisely the type of case where the interests of justice imperatively call for the admission and substantive use of the statements of both Sione and Breakfast as admissible evidence. In her statement to Mali, Exhibit V25, Breakfast recounted the events as follows. "Somewhere between January and February 25, when I was at Tando's place and we were in his room that is situated outside the main house. While we were in the room, Tando informed me that he had been approached by his employer called Chris. According to Tando, Chris wanted to kill his wife, and he told him that he could not do that, but he can organize people that can do that for him. Soon after that, Tando told me that he tried to organize people from Sweden and New Brighton, but they all failed him. But I am not sure of the date. Tando has again informed me that he has found a guy that he called Sizwe, who told him that he will kill the lady for him. According to Tando, the person that could successfully do the job for Chris would be paid an amount of 50,000 rand. I did not see the said Sizwe that promised to kill the lady for Tando and Chris. The said lady was said to be the wife to Chris, but I did not know or was never told as to what the reason of the killing was. On Monday night, 24:15, I'm not sure of the time, I was at Tando's room with him when he received a call in his phone. The caller told him that we have finished this and we want our money. After that call, Tando waked up and went outside. As I was hearing what was being said, I then decided to take his phone and to see who was calling him. On paging the phone, I noticed that the caller was Sizwe, who was saved on his phone as Sizwe. After that, he came back and joined me on the bed. After that, Chris, the employer of Tando, arrived there driving a double cab bakkie. I think that the color is silver grey and that he did not come into the house, but Tando went out to attend him. After that, Tando came back telling me that I must phone my brothers, Mabuti and Toto, to come and fetch me at his place. Tando and Chris have then left me there waiting for my brothers. At about 2300 hours, my two brothers arrived and we walked home. I then met Tando the following morning when he came to my place. He phoned me to meet him outside. On meeting him, he told me that he did not get the money from Chris, that he did get the money from Chris to pay Sizwe. I would like to state that on arrival of Chris, first before he went out with Tando, Tando came back from Chris and had a black bag that had money in it. He then requested me while waiting for my brothers, I must please count 50,000 rand out of the money in the bag. I did not count it. I then placed the said 50,000 rands in the bag and kept the other one side. I was then told by Tando that I must take the money, I must then take the bag with the 50,000 rand, and I did that. While I was sleeping at home, Tando phoned me to meet him outside with the money. I then took the bag and went outside. It is then that I noticed that he was driving with Sizwe in Sizwe's white car that he used to drive. I then went to bed again. That is all I know of that incident. At the time Mai minuted the statement from Breakfast, there was a dearth of information surrounding the death of the deceased, and the suggestion that Mai was the author of Exhibit V25's content is nonsensical. The attention to detail and the identification of key players attests to Breakfast's truthfulness at the time of making the statement. It is apparent from the foregoing detailed exposition that Sione, having been appraised of Breakfast's revelations to Mai, would, as Mai testified, have realized the quandary he was in and set in motion a process to broker a deal with the police and the prosecuting authority. In his Section 204 statement, he narrated the circumstances under which he began employment with accused number 1 and the approach made to him by the latter to find an assassin and his attempts to do so. He then narrated its sequelae as follows. Later that year, about August, September, October 2014, while I was on duty, Chris asked me to accompany him to his vehicle. As we were nearby his vehicle, he asked me if you knew someone who can, and then he made a sign with his hands across his throat, which meant to me that I knew someone who can kill someone. I remember that this conversation could not take place next to the car or inside the car, as Chanel was already sitting in the car. I replied that I will look for someone. Nothing further was discussed. I did not know at that stage who was to be killed. I then started to look for someone. I was interested in this plan as I believed that there was financial gain in it for me. I first went to a guy that I know by the name of Lama of Motherwell. I believed that Lama himself would not kill the person, but was hoping that he would know someone. I told Lama that my boss was doing the request. I was not supposed to tell Lama that it was my boss, as Chris requested me not to do so, as he wanted to protect his identity. Lama requested a meeting with Chris. A few days later, I introduced Chris to Lama. We met nearby the Dunkirk Stadium in the parking area of Kabani Tavern. I was not allowed to listen to the conversation, as Chris instructed me to wait outside the car. Lama was evading me after this meeting, and I did not spoke to him afterwards. Nothing came of this Lama-Chris meeting. Chris then started to put me under pressure to find someone else. I then went to another person I knew, Trumpy. I also know Trumpy as a person who would not kill the person himself, but would get someone to do the job. Trumpy was interested in the proposal. He also requested to meet with Chris. I arranged a meeting between them, and they met at Infinity. I was not present when the discussion took place. This meeting with Trumpy took place about 2 weeks after the meeting with Lama. The result was about the same as with Lama. Nothing came from it. Chris was putting me under more pressure. This was the first time he told me that the person he wanted to be killed was indeed his wife. He told me that it must happen before the school holidays, because once the school holidays began, it would not be as easy, as his wife would not be as easy to be found. The only reason he explained to me was that his wife spent too much money, while he, that is Chris, must work long hours for his money. He furthermore told me that a vehicle he had, a Renault Megane, which he had to sell because of financial problems. He told me furthermore that he then had to fix the double cab bakkie and then sell it. He said that he then sold it for 50,000 rand and paid the money to the bank. Therefore, this vehicle deal thing resulted in a huge financial loss for him. Furthermore, he told me either his parents or his wife's parents was forcing him to buy a home when he did not want to do so. He became more adamant by the day to find someone to do the killing of his wife. I then tried another person by the name of Andile or S. He just came out of prison at the time. I met him and he colored friends. But nothing came from this, just as the case with Lama Trumpy. The school holidays had long since passed until February this year, 2015, I met a person, Sizwe Vumazonki, I knew in Goko's Tavern. I knew Sizwe from Club 9 Yards. I knew that he knew people who could do the job. He was approached in the same way I approached the other people. He said that he was interested in the job, and we exchanged numbers. He would then contacted me later. A few days later, he contacted me. We met at Infinity a few days later. I was supposed to show him the places where he could find Chris's wife. Sizwe told me that he would come tomorrow. He did come that tomorrow. At that time, Chris had already showed me where he stayed. The next day, Sizwe did turn up and I went to show him. It was going now towards March. Sizwe disappeared. I was back to square one now. I started looking for other persons again. At this time, Chris was almost panicking. I made contact with my neighbor at the gym, a guy called Touch. He introduced me to Cadets. However, nothing came from this again as a result of finance. I contacted Sizwe on Facebook and informed him that the prize for the hit was not 40,000 rand. He replied that I must SMS my number to him, which I did. A few days later, Sizwe pitched up at my gym. He requested me that I must inform the two persons what was going on, and I did just that. The persons wanted a rented car to do the job. I then phoned Ntando's car hire. I phoned on my phone, and the amount was 6,000 for the rented vehicle. I borrowed money of 1,500 rand and gave 1,500 rand of my own money, and Chris eventually came and dropped 3,000 rand at the gym. I then handed the 6,000 rand to Sizwe. This was early April 2015, just before the schools opened. The vehicle was a white Toyota small car. A plan was put in motion. The plan was for Chris to bring his wife for a Sunday dinner to Infinity in the car. I would have been at the place where I would then show the vehicle, a Fiesta white in color, to Sizwe and his friends, from where they would then follow her as they could not kill her in front of the club. The plan was, however, cancelled as the wife did not want to come to Infinity. Chris then decided to show me another possibility where she could be taken out. Chris then decided to show me another possibility. The possibility he showed me was the friend's home with whom she was driving. The school opened the Monday after the holiday. I learned from Sizwe that they wanted to do the job that one of the mornings and followed her. As it was raining and was bad weather, they did not succeed. By that time already, I had shown Sizwe one night where the lady friend stayed. I also provided Sizwe with the vehicles of a registration number, which I got from Chris. The information that she was driving, I got from Chris. Because Sizwe did not succeed that week, Sizwe came back to me requesting that I must ask Chris to let him into the complex and the home. Chris replied that he could not do that as the complex was too secured and that a policeman was staying opposite him in any case. He would not be able to answer all the questions. Chris insisted that it must look like a robbery outside the gate or a hijacking. As Sizwe's plan could not work according to Chris, he told me that he will make another plan.
Well, that's judgment on the Christopher Panayiotis case. Now, we'll go back there, but right now, as we speak, you know that the economic freedom fighters, they're marching today in Pretoria to the Israeli embassy. Let's go live to our reporter, Sipho Stierman. A very good morning to you, Sipho, and welcome.
All right. Well, a very good morning to you and our viewers at home. Indeed, we are outside the Israeli embassy here in Hatfield, Pretoria, where hundreds of EFF members have already begun trickling in to picket outside the embassy. Of course, this is part of EFF's action, sympathizing with the Palestinians, saying that the human rights violations that are taking place in Israel are similar to what happened here in South Africa under the apartheid government. And if I can just step out of the shot, and you will see that the EFF members are already gathering steam, are waiting for the leadership that is expected to arrive at midday. And now, if perhaps I can just give you a bit of history to actually the reason that they decided to picket here today on the 2nd of November is not a mistake. The 2nd of November in 1917, that's when we had what they call the Balfour Declaration. That is when the United Kingdom government of the day, the British government of the day, made a declaration demanding that Jewish nationalities should be given a Jewish national state within Israel. So this is why we have this day. This day is significant. We did see, of course, internationally that the leaders of Israel went and met with the UK to mark the Balfour Declaration of 1917. Of course, to just give you a bit of context as well, the Israeli situation there remains one that is divided. There is no solution in sight. We do know that Palestinians are currently occupying what you call this. Palestinians are currently in the West Rand, and we also know that Palestinians are also in the Gaza Strip. However, in all of that context, there are allegations that the Israeli government itself has forces that are violating the rights of the Palestine communities. EFF, of course, is one of the parties that are sympathizing with the Palestinians. We do know that the South African government has also obviously called for a peaceful solution, saying that there should be negotiations that will lead to a peaceful settlement. And most of the time, what has always been often used in terms of finding peace, the solution of a two-state solution. But the two parties, that is the Palestinians and the Israelis, have never been able to come together on table to actually iron out the terms of this two-state solution. But another problem to this is that you know that Israel is a big ally of the United States. The United States sends about $3 billion per annum to Israel. So it is a complicated matter that the world in itself has not really been able to solve. However, today, EFF standing with Palestine, showing their support. Back to you.
Thank you, Sipho Stierman, coming to us live. We'll go back there a little bit more later to find out more. But right now, we go back to the court in Port Elizabeth, where Christopher Panayiotis is the accused in that case.
On Sunday, the 26th of April 2015, I was arrested and I made a confession. It became clear to me that I was in deep trouble and decided to cooperate with the police. On request, I made a few telephone calls to Chris, which resulted in a meeting in a vehicle that I was told would have been recorded. This statement was made in the presence of my lawyer. That is all I can declare. The lawyer referred to in the preceding paragraph of the aforementioned statement was Van der Spy, an attorney attached to the local justice centre. During this trial, his integrity was assailed by Mr. Price. The besmirchment of his character is scandalous and merits this court's opprobrium. I accept Swanepoel's testimony that he enlisted Van der Spy's professional assistance to assist Sione, and that the latter's disavowal of having been properly advised by him is false. Sione's admission that accused number 1 had orchestrated Jade's murder finds further corroboration from the most unlikely source, accused number 1 himself. In the anti-penultimate paragraph of his Section 204 statement, Sione adverted to a meeting in a vehicle with accused number 1. It is common cause that it took place during the evening of 29 April 2015 outside a Steers fast food outlet in an unmarked police vehicle equipped with listening and filming devices, and that their conversation and interaction had been recorded in both audio and video format. This activity finds legislative sanction in Section 252 A of the Act. Under the rubric, authority to make use of traps and undercover operations and admissibility of evidence so obtained, it provides as follows. 1. Any law enforcement officer, official of the state or any other person authorized thereto for such purpose, hereinafter referred to in this section as an official or his or her agent, may make use of a trap or engage in an undercover operation in order to detect, investigate or uncover the commission of any offence or to prevent the commission of any offence, and the evidence so obtained shall be admissible if that conduct does not go beyond providing an opportunity to commit an offence, provided that where the conduct goes beyond providing an opportunity to commit an offence, a court may admit evidence so obtained subject to subsection 3. Subsection 3 in turn provides that, and I quote, If a court in any criminal proceedings finds that in the setting of a trap or the engaging of an undercover operation, the conduct goes beyond providing an opportunity to commit an offence, the court may refuse to allow such evidence to be tendered, or may refuse to allow such evidence already tendered to stand if the evidence is obtained in an improper or unfair manner, and that the admission of such evidence would render the trial unfair or would otherwise be detrimental to the administration of justice. B. When considering the admissibility of the evidence, the court shall weigh up the public interest against the personal interest of the accused, having regard to the following factors, if applicable. 1. The nature and seriousness of the offence, including AA. Whether it is of such a nature and of such an extent that the security of the state, the safety of the public, the maintenance of public order, or the national economy is seriously threatened thereby. BB. Whether in the absence of the use of a trap or an undercover operation, it would be difficult to detect, investigate, uncover, or prevent its commission. CC. Whether it is so frequently committed that special measures are required to detect, investigate, or uncover it, or to prevent its commission. Or CC. Whether it is so frequently committed that special measures are required to detect, investigate, uncover, or to prevent its commission. Or DD. Whether it is so indecent or serious that the setting of a trap or the engaging of an undercover operation was justified. 2. The extent of the effect of the trap or undercover operation upon the interests of the accused, if regard is had to AA. The deliberate disregard, if at all, of the accused's rights or any applicable legal or statutory requirements. BB. The facility or otherwise with which such requirements could have been complied with, having regard to the circumstances in which the offence was committed. Or CC. The prejudice to the accused resulting from any improper or unfair conduct. 3. The nature and seriousness of any infringement of any fundamental right contained in the Constitution. 4. Whether the setting of the trap or the engagement of an undercover operation, the means used was proportional to the seriousness of the offence. And 5. Any other factor which, in the opinion of the court, ought to be taken into account. Thus, as a precursor to adducing a testimony to prove the admissibility of the evidence so obtained, Mr. Stander requested that I order that a trial within a trial be held to determine the issue as provided for in subsection 7. Mr. Price, whilst of the view that he was, and I quote, not entirely ad idem as exactly what the grounds are for the trial within a trial, close quotations, was constrained to concede that in terms of the directory language of section 252A, capital A7 of the Act, it would, and I again quote, preferable to determine the issue in a trial within a trial, close quotation. The subsection provides as follows. 7. The question whether evidence should be excluded in terms of subsection 3 may, on application by the accused or the prosecution, or by order of the court of its own accord, be adjudicated as a separate issue in dispute. Notwithstanding the ambivalent stance adopted by Mr. Price regarding the procedural device for determining the admissibility of evidence uncovered during the undercover operation, it is implicit from the terms of the section, however much its directory language, that where such evidence is sought to be excluded, the appropriate avenue to determine admissibility is the procedure contemplated by subsection 7. This approach was specifically endorsed by the Supreme Court of Appeal in State v. Matsabo, 2009 1 SACR 513 SAC as follows. Some point was made in the heads of argument about the magistrate's refusal to hold a trial within a trial when his legal representative twice objected to the admissibility of the trap evidence and asked that admissibility be tried as a separate issue. During argument, reliance on that ground was all but abandoned. Such uncertainty as remains should be dispersed. Our courts have long accepted that it is both desirable and necessary to the end of achieving a fair trial to try issues of the voluntariness of extracurricular statements or conduct of accused persons separate from the merits of the case. R.W. Dunga, 1934 AD 223. When a ruling is made without hearing the defense evidence, the defense is entitled to withhold its further testimony where it could only be given on terms which may prejudice the trial on the merits. In general terms, Section 252 capital A is also concerned with the voluntariness of conduct as the measure of whether an accused's conduct is induced by the circumstances of or methods employed in the operation rather than resulting from his own desire to commit the offence. In principle, I do not think that there is any material distinction between the accepted categories of cases where the separation of admissibility and merits is insisted upon and Section 252 capital A. Both inquiries seem to take account of and provide for the same inherent risks, such as discouraging an accused person from speaking openly when the trial of the merits may be influenced, if he does so, and the likelihood that failure to deal with admissibility properly and promptly will leave an accused in limbo in relation to the vital questions of whether he needs to testify and the substance of the case he has to answer. So also the prosecutor must know the limits of his case both for the purpose of leading further evidence and for cross-examination of the accused. For all these reasons, the holding of a trial within a trial will usually be appropriate to decide admissibility under 252A. We'll take the tea adjournment now. We'll start again at 11:15.
Well, there you go. That's the businessman and murder-accused Christopher Panayiotis. Well, they're taking a break right now, and of course, we'll pick up where they left off a little bit later. So we'll take a short break. We'll be right back after that.
I think winter is definitely one of those seasons where you can really show off your sartorial choices. You can start from a single layer of a shirt, actually starting with thermals, build it up with the shirts. You can have beautiful knits over the shirts, like we've done with Jay.
This film tells the story of a very, very significant political figure in the struggle for freedom in South Africa, who happened to be a woman. She was Nelson Mandela's wife.
The exhibition is an exploration into black femininity. Tabitha is a woman of color, and she is exploring the historical exploitation of the black female body.
Newtown Junction Mall hosted an epic contest in the cold where 3 top South African graffiti artists battled it out for the opportunity to become the Newtown Graffiti Face-Off Master.
For your weekly dose of entertainment news, tune in to Trends every Saturday from 12 to 1.
A lot of us rely on tech to survive, and Africa is already a mobile-first continent.
We built mobile technology that connects motorcycle taxis to commuters and businesses in real time.
My phone was the most important thing.
Africans are using technology to innovate. On Network, we have African technology and social media news. Even robots have heard about us.
Hello, watch Network on SABC.
For African technology and social media news, join Ms. Phumelele Zondi on Network every Sunday at 9 p.m.
Show me a greater power on the whole continent of Africa. Show me a greater power anyway.
6th of June 1918 was the establishment of our movement
to maintain that. We need to do something about the educational upliftment of the Afrikaner, and we also need to do something about the economic upliftment of the Afrikaner. And that was the two main goals at that stage in 1918.
The Broederbond never was a cultural organization. It was a state-capturing organization. It is, in fact...
I like that term.
It has captured the financial systems. It has captured the parastatals. It has captured cultural organizations.
For all your constitutional and legal matters, tune into Rights and Recourse on Sundays between 2 and 3 Central African Time.
It is 5 p.m. Central African Time, broadcasting live from Johannesburg. This is PM News. Mugabe is wanted in South Africa on a charge of assault with intent to do grievous bodily harm. Mugabe allegedly assaulted local model Gabriela Engels with an extension cord.
If the minister has granted the First Lady diplomatic immunity, then it then means that she will not be prosecuted.
There will now be 16 countries that form part of SADC. The Comoros was added as a member state during this summit. New Zealand rugby great Sir Colin Meads has passed away at the age of 81 following the battle with the pancreatic cancer. In 1999, Meads was named New Zealand's greatest rugby player of the 20th century. This year, a bronze statue of Meads was unveiled in his hometown of Te Kuti.
Stay tuned to PM News for all your news updates every Saturday and Sunday from 1500 hours.
Cape Town, a South African coastal city not only home to millions of people of different cultures and traditions, but is also a melting pot for a variety of flora and fauna. Approximately 1,400 kilometers northeast of Cape Town lies Soweto, a township suburb of Johannesburg, although in the same country these two South African cities are almost complete opposites in terms of climate, vegetation and culture. Soweto is a summer rainfall district with average temperatures in summer between 26 and 30 degrees Celsius. It is generally dry, hot and made up of much of high-fall grassland vegetation. At the opposite end, Cape Town's majestic Table Mountain alone has over 2,000 types of fynbos species, more than that in the entire United Kingdom. The city and much of Cape Town owes its phenomenal biodiversity to its Mediterranean climatic conditions. The winters are usually wet and cool with average temperatures of 13 degrees Celsius. Summers are dry and warm with an average high of 25 degrees Celsius. Recently, however, scientific research has indicated that the average summer temperatures in Cape Town are on the rise as a result of carbon emissions. Based on climatic analysis performed by Climate Central, a generally cool city such as Cape Town could experience much warmer temperatures as experienced in Soweto. Using a concept known as shifting cities, Climate Central and indeed researchers from South African Weather Service agree that unless emissions are drastically reduced, Cape Town's average summer temperature could be similar to those of Maseru in Lesotho at 28.3 degrees Celsius. If they are, however, not reduced, they could be similar to those of Soweto at 29.56 degrees Celsius by the end of the century. With these increments, it is very likely that weather patterns will shift to more intense and frequent drought periods, interspaced with short periods of flash floods, gale force winds, and more wildfires. Cape Town is already experiencing some of these severe conditions at its current average temperatures. Some of the worst fears are that droughts are likely to be more severe, frequent, and last longer. This poses major risks to food securities and economic opportunities. Decreased rainfall along with rising temperatures could lead to severe water shortages in a region already prone to frequent droughts. Over the last 40 years have been about 9 winters with rainfall well below expected average. This will lead to even lower dam levels and shortages of fresh drinking water. Furthermore, increased temperatures in association with drier conditions and wind may increase the incidence of wildfires. Even at current temperature levels, raging fires destroy crops, cattle, and have claimed a staggering number of human lives. The cost of keeping livestock and domestic animals may increase as the need for more water and cooling may increase. One needs to bear in mind that most of these disasters are already taking place at current average temperatures levels of 26.6 degrees Celsius. Imagine how much worse these disasters could get at 29.8 degrees Celsius a little less than 100 years from now.
Central Africa time, and as you know, let me remind you of your top stories this hour. The lawyer for Zaki Ahmad and other activists who were arrested after occupying the NPA offices in Cape Town yesterday says they're still being held in custody. The National Treasury has until Monday to review the social grants distribution process and come up with measures to resolve problematic issues between Social Security Agency, SASSA, and the Post Office. And businessman and murder accused Christopher Panayiotis will know today whether he has been found guilty for allegedly orchestrating the murder and abduction of his wife Jade in April 2015. And a mediation process between the SABC board and worker unions is due to start shortly. Now those are your headlines. Top story this hour. The SABC has given striking workers an ultimatum to return to work immediately. The broadcaster's management says that the strike called by the union Bamau was unprotected. The SABC cites a number of reasons for this position. It says staff members failing to return to work immediately will face disciplinary action and that the principle of no work, no pay will apply. Now, there's still no solution to the social grants payment issue between SASSA and the Post Office. Treasury has been given until Monday next week to review the process and report back to the affected parties. The Standing Committee on Public Accounts and the Portfolio Committee on Social Development are trying to break the deadlock between SASSA and the Post Office with regards to the latter taking over the responsibilities of paying grants from April the 1st, 2018. SASSA, the Post Office and the National Treasury will meet with the Interministerial Committee chaired by the President before reporting back to Parliament on Wednesday. Meanwhile, the committees have instructed SASSA to halt the advertising of the tender for the distribution of social grants that was scheduled for tomorrow.
I thought it was logical that if we say we're doing mediation, it means that there will be no tendering of anything because we don't know what the outcome is going to be. So I just assume that that one is obviously off.
The tender for the third, if it is still there, must be put on ice. The second point that I'm trying to persuade all of you on that side to accept is that there is no need for competitive bidding. And I hear what you're saying, DG, that you received a letter and you need to respond. We're trying to persuade you to write back to the author and say that there is no need, so the author must feel satisfied, because I agree that she needs to be satisfied. I'm making that a firm proposal.
Well, that's why we're asking you that question this morning. Do you think there's political will to resolve the social grant problem or debacle? Well, I would like to get your thoughts on the Twitter handle at SABC Newsroom as well as on the Facebook page. Let's go to the Twitter handle and see what you are telling me. This one coming from Teboho says, no, the minister is doing all in her powers not to, I suspect, that she had some vested interest or she wants to eat. Jambase says, government is the one to resolve this issue, says Jambase at Moiplas. Lahasa Molo says, yes, Minister Batabile should resign. And this one coming from Michael Big M says, honestly, I don't know what's the big deal, cause a new company must be appointed via proper tender. The sooner, the better. This is about the needy. Well said, Michael Butler Molo. Well, you can keep them coming. That was Michael Big M, rather. You can keep them coming. We'll read them as we continue. Meanwhile, 8 activists calling for President Jacob Zuma's arrest have been arrested in Cape Town. They occupy the offices of the National Prosecuting Authority to compel it to charge the president following the Supreme Court of Appeal's ruling. They gathered under the banner of #UniteBehindUs. Spearheading the action yesterday was the co-founder of the Treatment Action Campaign, Zaki Ahmad. Now, he is known worldwide for his activism on behalf of people living with HIV and AIDS in South Africa. The group marched from the Central Methodist Church on Green Market Square to the offices of the National Prosecuting Authority. They say the president should be put behind bars for his alleged involvement in state capture and corruption in government. He says the NPA has refused to let them have access to their medication. Now, they have been charged for trespassing but have not yet been released. Eskom bent the rules to help the Gupta Link company to buy a coal mine. Now, this is what unraveled during the ongoing parliamentary Eskom inquiry. It emerged that Tegeta Exploration and Resources was awarded an advance payment by Eskom that is about 58 times more than the required amount.
It was a day of explosive evidence. A former business rescue expert of the mine lifted a lid on how Tegeta went about to buy a distressed mine from Optimum Mine Holdings last year. The mine was up for sale for just over 2 billion rand, and Tegeta had a shortfall of 600 million. Banks who held the outstanding debt of the mine declined Tegeta a bridging loan to cover the shortfall.
On the 11th of April, we were led to believe by Tegeta that they were 600 million rand short on the purchase price that they needed in order to close the transaction. And the timing of the prepayment was on the very same day, in fact at 9 o'clock in the evening, for an amount relatively similar. So the amount was for 586 million as far as I can remember. And so we believed that the timing of that was something that required further investigation.
Advance payments are common at Eskom to cover pre-production costs, but the committee heard that in this instance, the payment covered Tegeta's shortfall. In fact, pre-production costs like equipment were 58 times less than the advance payment. Marsden says he laid charges with the Hawks in July last year, but claims the progress of the probe had been disappointingly slow. The inquiry wants monies to be recovered.
How can we get those monies back? Because they belong to the community of South Africa. They belong to the poor people.
The implications is on ordinary people who are now going to be forced to pay 20% more for electricity because of the mismanagement of Eskom.
It also emerged that it was the auditing firm KPMG that facilitated the purchase of the mine on behalf of Tegeta. Pulelani Philip, SABC News, Parliament.
ANC struggle veterans and stalwarts have called for the President Jacob Zuma and some in the NEC to resign and allow new recruits to come in to assist in the self-correcting of the party. Now, this emerged at the memorial service of long-serving ANC stalwart Violet Sarah Maclo at the Pact Acacia Community Hall in Pretoria yesterday.
Remembering their fallen heroine, Violet Maclo left the country together with her late husband Joe Maclo and set up the first ANC offices outside the country. Their home in the Peleng section in Lubatse, Botswana, became a transit point for many leaving South Africa. Speakers at her memorial say the ANC does not embody the principles of people like Maclo.
How many times do they call the elderly people to come in to give them a report and also to listen to the veterans if things are not going correctly? They must go to the veteran and ask them, well, are we correct if we are doing like this and like this? then things will go wrong.
We need to be relevant to the issues and circumstances that we find ourselves in. We need to be vocal. Like the ANC Women's League used to be vocal, things would never happen to women and the Women's League keeps quiet.
The family want this unsung heroine to be remembered for her role in the liberation of South Africa.
We want South Africa to remember that there are people who unselfishly gave their lives to the struggle of this nation. People who did not want to be paid for fighting for freedom for this nation. People who were prepared to be deployed to anywhere in this world in order to go and sell our struggle to be supported by foreign nations, and she is one of those people.
Matlo will be laid to rest on Saturday, the 11th of November. Solufelo Matibedi, SABC News, Pretoria.
Learners who have alleged to have been sexually assaulted by a scholar patrol at a primary school in Soweto here in Johannesburg are being assessed to determine if they could testify in court when the trial begins. More than 50 learners have positively identified the accused as their alleged perpetrator. Now, this emerged in court yesterday, where the 57-year-old accused made a brief appearance.
The state says it's taken statements from 55 of the children, most of whom have implicated the patroller. It was yet another brief court appearance. The 57-year-old man walked into court, his head covered with a jacket. The state says 6 of 7 children who attended an ID parade have positively identified the man as the one who sexually abused them. Another victim, too traumatized to even identify the suspect. Parents say it's affected them psychologically.
My friend went there with her child. She was not right. Even the children were crying. They are very traumatized, especially when they saw this old man.
The Education Department says it's assisting both parents and children.
We're going to have a task team where we have parents' representation and all other stakeholders are there. That's where we agree on what is it that we're going to be doing moving forward. We are making sure that the children are ready to be appearing in court.
The 57-year-old is back in court on the 30th of November. Manqaba Mchunu, SABC News, Soweto.
The 45-year-old man accused of raping a domestic worker in Bronkhorstspruit will be back in court today. Now, he faces 3 rape charges, 2 of sexual assault involving dogs, kidnapping and malicious damage to property.
Bronkhorstspruit, edged on the Gauteng-Mpumalanga border. In recent months, several alleged racially motivated incidents. A week ago, this woman shared her harrowing experience with SABC News. She detailed a 12-hour ordeal in which she was repeatedly raped. But her nightmare didn't end there. She claims she was forced to perform sexual acts with 2 dogs.
He forced me into his room and instructed me to undress. I refused. He wanted to beat me and then assaulted his parents. He then blocked his room door with a table and raped me.
This is seemingly not an isolated incident. 2 months ago, this girl, her brother, a friend and their dogs went for a run. The dogs ran into private property and they followed. The owner accosted the girl, accusing her of trespassing. She said she was handcuffed to a tree, assaulted and held at gunpoint.
How can a 9-year-old steal a springbok? Is it possible? That's the reason that they gave. But then what they are saying is that they were not shooting at the kids, they were shooting at the dogs.
The 2 suspects were released on bail of 3,000 rand each. They face attempted murder charges.
Chilean Pillay, SABC News, Johannesburg.
To the U.S. now, prosecutors in New York have filed terror charges against an Uzbeki immigrant accused of killing 8 people in a truck attack on Tuesday. The FBI, meanwhile, says that they've located a second Uzbeki man wanted for questioning in connection with the attack. The suspect, Sayfulo Saipov, was hospitalized after a police officer shot and arrested him, bringing an end to Tuesday's rampage. He confessed to authorities while in custody that he began planning the attack a year ago. Saipov was charged with 1 count of providing material support and resources to a foreign terrorist organization and 1 count of violence and destruction of motor vehicles. The 10-page charging document said Saipov waived his rights to remain silent and avoid self-incrimination in agreeing to speak to investigators without an attorney present. New York City police said that Saipov had carried out the attack according to instructions that he found posted online by the Islamic State, on whose behalf he claimed to have acted. U.S. President Donald Trump has called for the suspect to be put to death. The U.S. Embassy and the South African Music Rights Organization have signed an agreement that is said to see over R1 million go to the preservation and development of indigenous African music.
The signing ceremony marked the end of a process that saw the U.S. ambassadors consider projects for funding in over 100 countries. The grant, worth just over 1.2 million rand, will go to the Samro Music Archives IAM project, which stands for Indigenous African Music. It also refers to the African spirit of Ubuntu. I am because of who we all are. It will focus on transcribing and documenting Southern Africa's rich indigenous music heritage for the purpose of research, performance, conservation, preservation and promotion.
I know South Africa is facing economic, political and social crises every day. But behind these crises, we unravel a more subtle and a far-reaching concern, and that's the crisis of identity, which some would like to say is the crisis of our humanity, the crisis of that which makes us human. The crisis of identity impacts on cultural cohesion, it impacts on social inclusion, and it impacts on mutual appreciation. The crisis has driven us apart in many ways, so that we are easily divided, manipulated, and undermined. We no longer see the rainbow nation, we no longer have the Nelson Mandela figure to bind us, and we increasingly turn on each other rather than work together. This was painfully apparent this past Monday, when some of our fellow South Africans brandished the old and burnt the new South African flag. For many of us, that hurt terribly. But today, that's not what we're here to talk about. We're here to talk about unity.
Since 2003, the U.S. Ambassador's Fund for Cultural Preservation has supported the preservation and conservation of a host of South African projects, among them rock art sites, the Cradle of Humankind, Mapungubwe Museums, the Mandela Center for Memory, and the Lilies Leaf Archive.
Throughout my own tenure as Charge, I really emphasized arts and culture as a way to strengthen the ties between the United States and South Africa. Preserving and sharing musical heritage has to be one of the most important things that we do in the service of those ties. And it's something we've been doing together for many years.
The Foundation of South Africa's music rights collection body funds and supports projects that aim to grow music performance and appreciation in the country. The Braamfontein event featured a performance of the Bokana Daya composed music to the words of Thabo Mbeki's now famous "I Am an African" speech.
Elizabeth Grove North Street in front of the Israeli embassy in Pretoria is now closed as the economic freedom fighters get ready to picket. Now let's go for an update on the story live to Pretoria. Ntakwana Ngatani is there, our reporter. A very good morning to you, Ntakwana, and can you give us an update on to what is happening there in Pretoria now as we speak?
Yes, good morning, Elvis. We come to you from right in front of the Israeli embassy here in Pretoria, where from very early on in the morning, EFF supporters started gathering here, and the protest itself is taking full momentum. Now, earlier on today, we saw counter-protesters of a group called Bridges for Peace trying to counter-protest, trying to say that they support Israel, but EFF supporters were having none of it. What they did was they told those counter-protesters that they got the permit for this march and therefore they have no right to be here. and they said to them that if they didn't move, they would be forcibly removed. So much later on, we saw them take their banners and get away from this area. But what I can tell you is that economic freedom fighters, supporters have on T-shirts with the flag of Palestine on them, and on the back of those T-shirts it says Free Palestine, and they say that this is part of the efforts worldwide to ensure that as they see it, the apartheid or the segregation that happens in Palestine does not continue, and the continued occupation of areas of Palestine by Israel stops. But if I can just look at some of the placards that I see here, one says, "One democratic Palestine for all," others say, "Free Palestine, stop Israel's ethnic cleansing of Gaza." Now, this protest or this picketing will continue here. Earlier on, we were expecting the protest to go from Church Square here in Pretoria and walk through Pretoria, but we understand that EFF changed that plan. So we see more and more of their supporters arriving in buses here in front of the Israeli embassy. But also what we can expect is that we asked some of the staff members here at the embassy if anybody would come out to acknowledge the presence of EFF out here, and on condition of anonymity, those staffers told us that no, nobody would officially come out, but they are aware that the protest is going on here. So the protest continues to celebrate, or rather to mark, the day that Britain, or the Foreign Secretary of Britain, wrote a letter that made it right for Jews to move to Palestine and eventually establish the State of Israel, that Palestinians say was wrong, that the British did not have the right to do that. But as I say, in the United Kingdom today, we understand Prime Minister Theresa May is hosting Benjamin Netanyahu for a dinner in which the leader of opposition, Jeremy Corbyn, will not be attending. These are some of the activities that are happening worldwide, but this day clearly making a mark everywhere in the world, as well as here in South Africa and here in Pretoria in front of the Israeli embassy here in Pretoria. Elvis.
That's Ntakwana Ngatani, our reporter live in Pretoria. As you know, the EFF is marching towards the Israeli embassy in, of course, the protest in solidarity with Palestine on the 100th anniversary of the Balfour Declaration that lent British support to the migration of Jews to Palestine and the ultimate formation of the State of Israel. Well, right now, businessman and murder accused Christopher Panayiotis is in court. Let's go there live.
That is correct, sir. The following excerpts mirror the technique employed throughout Sioni's questioning by Mr. Price. The answers upheld the proposition. A moment's reflection on his responses established Sioni's partisanship to accuse number one's cause, and the exercise conducted hardly passes muster as cross-examination. It constitutes a plethora of leading questions, and the answers furnished have, in my judgment, no evidential value whatsoever. I unreservedly accept the state evidence that at the outset of his interrogation at the unit's offices, Sioni, mindful of the dilemma he found himself in, expressed her willingness to fully cooperate with the police and entreated Swanepoel to facilitate an audience with accused number one for obvious reasons, namely to ameliorate the consequences of his own actions. In considering the admissibility of the recorded conversation between Sioni and accused number one, the former's concocted version must be disregarded and the matter determined solely on the evidence adduced by the state, to which I now turn. I interpolate to say that the evidence adduced from his mother, brother, and Breakfast's mother that he had been assaulted is in conformity with his own, a complete and utter fabrication, and falls to be rejected. It is common cause that the exchanges between Sioni and the unit's members concerning the attempts to telephone accused number one and the actual conversations between him and accused number one were recorded. The transcript was, as adverted to hearing before, introduced into the proceedings as Exhibit BG5 and featured prominently in the cross-examination of Swanepoel and the unit's members. As adumbrated herein before, the sole ground initially advanced by Mr. Price for the exclusion of the video and audio footage was the alleged ill treatment of Sione by the unit and the police members involved in his earlier interrogation. During the course of Bosch's cross-examination, however, the exclusionary ground was suddenly widened to now include the scenario postulated by Section 252 capital A2E. It was put to Bosch and later to Swanepoel that the plethora of telephone calls to accused number 1 on the 28th and 29th of April 2015 inexorably induced him to succumb and meet with Sione, and that this degree of persistence fell foul of the provisions of Section 252 capital A. During Swanepoel's cross-examination, the ambit of the challenge was further extended to now include the scenario postulated by subsection H. It was put to him that the calls made exploited accused number 1's emotional state to such an extent that he was impelled to meet Sione. It is indeed so that several calls were made to accused number 1, but it is common cause that only a few were answered. In any event, accused number 1 is the only person who could have told us what effect the calls had on him. Notwithstanding the protection afforded to an accused person by a trial within a trial procedure, accused number 1 chose not to give evidence. That conscious decision has consequences. As Leach J.A. remarked in Hone v. Superstore Mining at 2017, 1 All SA 681 SCA at para 49, moreover, there is no evidence that the appellant in fact acted under duress. Objectively viewed, and in the light of what I have said above, there is no threat of any unlawful evil being done to him if he did not cooperate with the respondent. His counsel had stated in cross-examination of the respondent's witnesses that the appellant would deny that he had made the admissions freely and voluntarily, and would testify that during breaks in the recording he had been further threatened and told that his and his family's lives, including those of his parents, who were employed by the respondent, would be destroyed, and that if he did not admit to provide the information required, he would be imprisoned for life. However, notwithstanding this and despite the unusual protection afforded by the trial within a trial procedure that was adopted, the appellant failed to give evidence. That too was a decision he was entitled to take. But actions have consequences, and one of the consequences that flows from the respondent's failure to testify is the inference that his evidence was likely to damage his case. The reliance on the content of Exhibit BG5 as evidencing impermissible conduct on the part of Swanepoel and his team is entirely misplaced and an exercise in opportunism. An objective analysis of Exhibit BG5 establishes not only that Sione was willing and cooperative, but that the decision to meet rested with accused number 1. His pre-meeting utterances to Sione indicate quite clearly that he recognized that the cat was almost out of the bag, and the decision to meet was to ensure that it remained inside. As adumbrated herein before, accused number 1 elected not to testify during the trial within the trial. Mr. Price nonetheless submitted that such omission is of no consequence whatsoever. Given the assertions made to Sione and referred to in paragraph 41 herein before, the submission is an astounding one. I say so for two reasons. Firstly, during Swanepoel's cross-examination, he was referred to the provisions of Section 252 capital A, 2E and H of the Act, and the point was sought to be made that accused number 1 succumbed to the incessant phone calls and met with Sione. Up until then, it was never accused number 1's case that the decision to meet with Sione was in any way actuated by the calls made to him. When I initially invited Mr. Price to indicate the grounds upon which the admissibility of the evidence was being challenged, no reference whatsoever to the circumstances enumerated in subparagraphs A to M of Section 252 capital A 2 was made. The challenge was, as Adam Brayton hearing before, limited to the generalized defense ex facie the Section 115 statement. Secondly, what I was being asked to do was to infer that accused number one in fact succumbed to the incessancy of the calls made to him and met with Sioni. The invitation to do so must be declined, for it is based entirely on conjecture. As Boshoff J. pertinently pointed out in S.V. Cooper, 1976-2 essay, 875T at 889A to C, there can be no inference unless there are objective facts from which to infer the other facts which it is sought to establish. In some cases, the other facts can be inferred with as much practical certainty as if they had been actually observed. In other cases, the inference does not go beyond reasonable probability. But if there are no positive proof facts from which the inference can be made, the method of inference fails, and what is left is mere speculation or conjecture. As pointed out by Denning.
We're going to bring you more on that judgment a little bit later. Right now, we go to Pretoria, where the EFF is rallying, and of course the national spokesperson, Dr. Ndlozi, is on the stand. Let's go there live. That's Dr. Ndlozi there, the national spokesperson of the EFF, getting the crowd up and running there. Of course, they sing all the struggle songs for now. When he does speak, we'll go there live. But let's go back to court in Port Elizabeth. the Christopher Panayiotis case.
At Exton during the afternoon of 29 April 2015, where during the course of their discussion, accused number one on several occasions expressed his anxiety at being called by Sione and begs the question why. This show of reticence was feigned and his conduct dramatized to induce Exton to believe that there was no connectivity between himself and Sione. A holistic appraisal of the evidence adduced and the content of Exhibit BG5 establish that accused number one's reluctance to initially either return Sione's calls or to fully engage in conversation with him on 28 April 2015 was actuated by his belief that Sione had in fact been arrested by the police and was calling him at their instigation. Exton's uncontroverted evidence was that whilst at the unit's offices in Shirley Street, he received a telephone call from accused number one to meet, agreed thereto, and that a discussion took place in his own office at 3rd Avenue in Newton Park. It is common cause that Exton recorded this conversation, as appears from my recording 13 on page 25 of Exhibit BG5. It is apparent therefrom that accused number one's primary motive for the meeting was to establish whether Sione had been arrested. The inference can thus properly be made that, fortified by Exton's deception that he had not, he initiated further telephonic contact with Sione during the course of 29 April 2015, which eventuated into the meeting between them later that evening. Exhibit BG5 furthermore establishes not only that the choice of venue emanated from accused number one, but that he proceeded thence with money to hand to Sione and later blatantly lied to Kun concerning Sione's intended destination. During Swanepoel's cross-examination, the ambit of the challenge to the admissibility of the recorded conversation between accused number one and Sione was once more widened to now include the scenario postulated by subsection 2A of section 252 capital A. It was put to him quite erroneously that Bosch had testified that accused number one had been entrapped and that under those circumstances permission would have had to be obtained from the Director of Public Prosecutions. The assertion made is misleading in the extreme. The only mention of entrapment by Bosch occurred in the following exchange between himself and Mr. Price, where in response to the question, and I quote, "Now the section 17, you know what section 17 is," close quotation, he answered, "Is that with regard to the entrapment," close quotation. Bosch's rhetorical answer was then elevated to an admission that Sione had been used as a trap. This appears clearly from the following question put to him, and I quote, "Bosch, when he testified, said that the purpose was to entrap Panayiotis. I am using his own words. Is that correct?" There would have been conversations between the two men. We didn't know what to expect. We were just hoping for what to expect. Nee, ek verstaan dit. Ek dink nie u verstaan my vraag nie. Look, you have already obtained permission to make the calls. Now you phone him again. Was that call's purpose only to go a step further to now record him in the car? That is correct, my lord. Mr. Bosch referred to that as the entrapment of Mr. Panayiotis. Do you agree? If that is the wording of Mr. Bosch, that is his. Mine is that we were going to get permission to record Panayiotis. You realize if the court were to find that this was an entrapment, then you would have at first got the permission under section 252 capital A. The proposition made from the office of the Director of Public Prosecution and the unit required approval for the proposed operation is misleading in the extreme. As a matter of law, section 25 capital A placed no such obligation on Swanepoel. As Wallace A.J. remarked in State v. Kotzer, 2010 1 SACR 100 SCA at paragraph 22 to 26. The section deals with both traps and undercover operations. Whilst these usually go together, there will be cases where an undercover operation may involve no element of a trap. Thus, for example, the infiltration of an undercover agent into a gang planning a bank robbery, a cash-in-transit heist, or the overthrow of a government will not necessarily involve any element of a trap, but may merely be the exercise in obtaining information. Nonetheless, it may involve infringements of the rights to privacy, as with the use of a telephone tap or some other form of listening device, and could potentially be subject to constitutional challenge. The section explicitly addresses that situation and provides that such actions are permissible. It also recognizes that undercover operations may have elements of a trap and hence treats the two together. The present case is a classic instance of an undercover operation that also involves the use of a trap. The section lays down two approaches to the admissibility of evidence obtained as a result of the use of a trap. Evidence is automatically admissible if the conduct of the person concerned goes no further than providing an opportunity to commit an offence. If the conduct goes beyond that, the court must inquire into the methods by which the evidence was obtained and the impact that admission would have on the fairness of the trial and the administration of justice in order to determine whether it should be admitted. It must be stressed that the fact that the undercover operation or trap goes beyond providing an accused person with an opportunity to commit the crime does not render that conduct improper or imply that some taint attaches to the evidence obtained thereby. All that it does is create the necessity for the trial court to proceed to the inquiry mentioned in the previous paragraph. I stress this because there was a misconception in this regard at the trial. At various places in the cross-examination of Blanche, it was put to him that the section imposes constraints upon what may be done pursuant to a trap, and this suggestion is repeated before us in the heads of argument for Kotze. In summarizing the argument in this practice note, counsel said, "Die getuienis van die lokvink behoort as ontoelaatbaar gereël te word, aangesien die optrede van die lokvink verder gegaan het as die blote skepping van geleentheid om misdrijf te pleeg." This is a misconception as to the effect of section 252 capital A1, and it is well therefore to lay to rest. Section 252 capital A1 does not purport to describe the manner in which undercover operations or traps are to be conducted by the police. It merely distinguishes on the basis of the manner in which the trap is conducted between instances where the evidence thereby obtained is automatically admissible and instances where a further inquiry is called for before the question of admissibility can be determined. Section 252A1 prescribes a factual inquiry into whether the conduct of the trap goes beyond providing an opportunity to commit an offence. Section 252 capital A2 describes a number of features which may indicate to a trial court that the undercover operation or trap went beyond an opportunity to commit an offence. It was conceded by the prosecution and held by both the magistrate and the court below that the conduct of Blanche and this undercover operation went beyond merely providing the opportunity for the commission of the offence. Unfortunately, the findings of both courts on this matter were not fully reasoned. A closer examination of the provisions of section 252 capital A1 and 2 is therefore desirable. The starting point is that in each case where the evidence of a trap is tendered and its admissibility challenged, the trial court must first determine as a question of fact whether the conduct of the trap went beyond providing an opportunity to commit an offence. It does that by giving the expression its ordinary meaning and makes a decision in the light of the factors set out in subsection 2. I accept that if one simply peers at the language of section 252 capital A2, there appears to be an anomaly arising from the fact that some matters logically anterior to the conduct of the trap itself are to be taken into account in considering whether it went beyond providing an opportunity to commit an offence. However, there are always dangers in such a linguistic analysis removed from the context of the section as a whole. and the potential anomaly may on closer examination be more apparent than real. Thus, the fact that the trap was set without the authority of the Director of Public Prosecutions, or that the conditions set by the Director were disregarded, may well indicate that the trap went beyond providing an opportunity to commit an offence. Otherwise, they will be irrelevant. The fact that the offence in question is of a minor nature may indicate that the effect of the trap is to place disproportionate temptation in the path of the accused, so that it went beyond providing an opportunity to commit an offence. In considering the question whether the unit's conduct went beyond providing an opportunity to commit an offence, a court is enjoined to have regard to the raft of features adumbrated in Section 252, capital 2A to N, where applicable. It is apposite, given the confusion surrounding the first of the features enumerated in the subsection, to dispel the notion that the authority of the Director of Public Prosecutions is a prerequisite for the engaging in an undercover operation by a law enforcement officer. The Act imposes no such duty, cadet quaestio. As adverted to earlier, Section 252, capital A, did not oblige Swanepoel to obtain the Director of Public Prosecutions' consent to conduct the undercover operation. There is furthermore no suggestion that other techniques were available to unmask Jade's murderer. It is common cause that Jade's murder had unleashed a media frenzy. It, together with the informant's revelations, and confirmed by Sione, impelled the adoption of a strategy employed by the unit, and their modus operandi is not open to critique. An objective assessment of Exhibit BG5 establishes that accused number 1 was not induced into meeting with Sione. It was his own self-preservation which caused him to make the calls which in fact precipitated the meeting. The mere fact that the initial calls were made at the instance of the unit is entirely irrelevant. The fact of the matter is that the majority went unanswered, and when regard is had to the import of the actual conversation between accused number 1 and Sione prior to the actual meeting, it is clear that no exploitation, as envisaged in subsection 2H, in fact occurred. Pardon. It is furthermore clear that the evidence procured established accused number 1's complicity in Jade's murder, and there is no room to contend that the unit acted in bad faith. I am satisfied that the unit's conduct did not go beyond providing an opportunity to commit an offence. But even on the assumption that it could conceivably, upon an entirely subjective critique of the unit's conduct, be contended that it went beyond providing an opportunity to commit an offence, the evidence garnered would, in my view, nonetheless be admissible, for its admission is neither unfair nor detrimental to the administration of justice. Rather, its effacement would be inimical to the interests of justice. The foregoing constitutes my reasons for ruling that the audio and video recordings Exhibit CB1 is admissible in evidence. During his final address, however, Mr. Price entreated me to revisit my ruling, contending that the evidence adduced during the defence case justified its reconsideration. It is indeed so, given the interlocutory nature of rulings on the admissibility of evidence, that a court is entitled to reconsider its earlier rulings, but the argument is advanced is spurious, proceeding as it does from the misconception concerning a law enforcement official's power to engage in an undercover operation. As adumbrated hereinbefore, Section 252 capital A imposes no obligation on a police officer to obtain the Director of Public Prosecutions' consent to engage in such activity, and the adduction of testimony by Advocates Gandon and Goberdan from the Office of the Director of Public Prosecutions was, despite the fanfare, entirely irrelevant, and so too the guidelines. Whilst these may apply to members of the prosecutorial services they are clearly not binding upon members of the South African Police Services. The import of the aforementioned dialogue between Sione and accused number 1 establishes his complicity in Jade's murder beyond all reasonable doubt. Its admission into the smorgasbord of testimony against accused number 1 nonetheless evoked an assault on the authenticity of both the video presentation and the transcript of the recording. Warrant Officer Kelamani, attached to the electronic surveillance unit of the South African Police Services, was responsible for downloading the video recording from the SD card onto his computer. He burned the DVD, received in evidence as Exhibit CB, and the transcript of the conversation as Exhibit CB1. During cross-examination by Mr. Price, it was suggested to him that both the video and audio presentations could have been manipulated. Whilst it is correct that Kalamani assented to this speculative hypothesis, the attack soon dissipated and was abandoned. Nonetheless, the attempt to impugn its genuineness was imprudent and symptomatic of the malaise which afflicts the defense case. The video and audio recording provides a graphic account of the interaction between Sione and accused number 1 and posits the latter as the preeminent villain. The transcript is unsusceptible to paraphrase, and its reproduction into this judgment is imperatively called for, particularly in light of accused number 1's disavowal of any complicity in Jade's murder and the unwarranted and scurrilous imputations of dishonesty directed by the defense against several witnesses called by the state. It reads as follows: TS referring to accused number 1 and CP refers to the accused number 1. Things aren't right now. Why? Babawa called me and said the police was there at my house. Everything is changing now. But why are the police after you? I don't know. I think there's an informer somewhere, somehow. Did these guys blit? Which ones? Your friend, Sizwe. Did they tell anything? No, even them, they are on the run. Oh. I told them they must not be here. Where are they going to? They didn't tell me. I changed my SIM card. Yes, but you need to change it again now. After this, I'm going to call you. What? I'm going to call you on my new number. No, you are not. You just missed call me. Don't phone me or SMS me. What's going on, boss? I don't know, bro. Hey, this thing, I didn't see it was going to be like this. Here, what is this? Plus minus 5, reference to 5,000. Where are you going to now? I'm going to Jeffreys Bay. I'm worried about my family. Boss, this thing, I didn't know it was going to be like this. I thought it was going to be easy. Yes, but why did they say to you when they fetched you the other day? They fetched me and then they asked me questions. What did they ask you? F questions. Hey, nothing serious, boss. Tell me. Did they ask if you were involved? Yes, sort of something like that. So what did you say? Those are the stupid ones. So where did they take you? They took me to the police station. There they took my statement. But in my mind, you must told me we will be investigated. Yes, so I was ready for that, but I was not ready. So why are you running away? They keep coming to my house. Did you take your phone anywhere? Yeah. No, your other phone. I destroyed it. Did you? I told them to destroy it and then I destroyed it. Yeah, and the SIM card and everything, did you throw it away? Yes, I'm not using the old number, I'm using this number. Okay, so they didn't ask anything about me? No. Or if I'm involved or anything? Yeah, no, yeah, but haven't they asked you? Yes, they have asked me, but now, you've been phoning me all day and they've been tracing my phone. The thing is, who could I call? I had no one to call. I know, but now you have to destroy that phone. I have to tell them that you phoned me, otherwise they are going to think that I am involved. Yeah, so you need to destroy that phone now. The phone and the SIM card, my boy, both. Yeah. I interpolate to say that at this juncture, the video shows accused number 1 seated on the front seat of the vehicle, turning around and frisking Sione. The transcript continues. I don't trust you now. Oh, I'm just checking. Even me, I'm not trusting you now. Just the thing of the police that are coming to my house. I swear on my life I didn't say anything. But they are obviously seeing who I have been phoning. They are taping my phone and my every number I phone. They are investigating my family too. Somebody said something. Yeah, because it's like a murder thing now. It's not like a robbery or something. But that's what I said to you. It became a kidnapping and a murder instead of just making it a robbery outside the house. I think about my family now. I think about Sianda. I think about the 2 little girls. I think about my gym. They went to search your house, says Sianda. Sianda says so, you see. But there's nothing there, so stop stressing. You know why I'm actually stressing? I'm not safe anymore. Because I have to run away even from Sizwe, because I told you, Moss, what Sizwe said. That money was too little because now they are running away too. Yes, but it is because of them, Tando. They made it the way they did. They made it so big, but they have run away. How many of them? I don't know. I only know Sizwe. Is it black guys or colored guys? Sizwe is a black guy. And the others? I don't know if the others, but I know Sizwe. I was communicating with Sizwe. But I don't know if Sizwe was walking alone. Okay, listen to me. I'm going to report that you phoned me now, and then you are going to call me. No, but you are going to destroy that phone. So you are going to give them my number. Yes, I have to tell them. They're investigating me. If I lie to them, they're going to take me in. So I'm telling you, in half an hour, I'm going to phone the investigating officer. He was at my house now. That's why I can't talk to you all the time. And my uncle is around. He's all around me. So I'm going to tell them that you came to see me wanting to borrow money because people took you for questioning for steroids. You need to go and hide in Jeffreys Bay for a while and keep quiet. Sianda, what about the rent for the gym? Yes, but I can't do anything because I'm under investigation, so I can't give over money all the time. So don't worry me, and Sianda will talk. Yeah. Okay, are you going to hide out that side in Jeffreys? Yeah, I'm going to stay a while there, or maybe some. Okay, I'm going to say you must destroy your phone now and the SIM card, and I'm going to say you said you're going to East London. Okay. Okay, I'm going to be okay as long as they never know about us, Tanda. I never ever. I only ever helped you with the gym. I never did anything with you. I'll sort out your family. You lie low, okay. You need to be gone for a few months till this thing calms down. If I need you, I will miscall you. No, not on this number. On what number? You're going to miscall me once and then you're going to wait until I get another phone and a SIM card. Yeah, all right, okay. There is about 5 there. You sort yourself out. Yes, okay, because I'm all out now. This thing has cost me a lot of money. The family is also looking at me. Serious, yes, okay. This thing is not right now. No. These boys made it big. I told you to let them do it outside the house and take the bags and the rings, and then they didn't take the watch or anything. They just left. They just left everything there, you see. So now it looks like a hit now. So they are after me, and that's why I can't just meet you in front of people like this, Tando. Okay. Okay, don't phone me and don't SMS. They are watching the SMS because you said. Yeah, but I SMS you and you don't reply. Me at the other side, I'm hiding, and then, no, but you need to give me time. So from now on, you just give me one missed call on this number, first time and never again. Don't ever phone me or SMS me to this number because they are listening to us. Even now, well, yes, but I put it off. When you were talking on the phone, they are listening. That's why I have to report this now. Okay, all right, I'm going to say you are going to East London. Okay, cheers. So I need to miscall you. Yes, but then you wait for me to phone you back. It will be gleaned from the aforegoing and the video footage that after accused number 1 frisked Sione, there is a discernible attitudinal change in the interaction between them. His initial circumspection all but vanishes, and the intricacies of their murderous conspiracy are laid bare by accused number one's forewarning, and I quote, "Somebody said something, yeah, because it's a murder thing now. It's not just like a robbery or something. It became a kidnapping and a murder instead of just making it a robbery outside the house." Close quotation. The aforegoing unsolicited utterances and admissions by accused number one vouchsafe the truthfulness of both the narrative in both Breakfast and Sione's police statements and demystifies the concocted defense. Particularly telling is accused number one's comment, and I quote, "I told you to let them do it outside the house and take the bag and the rings, and they didn't take the watch anymore."
Viva EFF, viva! Long live the undying spirit of Yasser Arafat, long live! Long live the undying spirit of Yasser Arafat, long live! Manka! Away to Manka! Let's get closer, comrade Karmata Melenga Ofe. Abizani fire plique. Abizani fire plique. Abizani fire plique. Awi fire plique. EFF Chisapitor. Awi Chisapitor. EFF Chisapitor. Awi Chisapitor. Abizani fire plique. Awi fire plique. Abizani fire plique. And it is the fire plique. EFF ingene pitol. Awi ingene pitol. Manta. Comrades, I'm going to welcome the SG, who is going to run the program for us. SG, our Secretary General, Commissar Godrich Gardi. He is going to be leading us with the program today. Manta! Manta! Away, two! Away with apartheid Israel, away! Away with apartheid Israel, away! Manta! Away, two! Mata! Arona! Mata! Arona! Manda! Akingele Karat, Tati Pedro, Trishalom Friend, Awi KGB, yo yo, Awi KGB, yo yo, Awi mama ye, yo yo. Awe abanye baitan, we EFF. Awi zolo, yo. Atingene karat, Tati Pedro, Fishalom Queen. Ati Chio Makerela, Chio Makerela, Shangela na mabala singa na ulomkon songe. Esizoto la upe tama akan. Awe Shangela na mabala singa na EFF songe. Esizoto la upe tama akan giza le tamama.
Once the debris is removed, it is clear that accused number 1 retrieved it from his business premises at the time he disabled the alarm system. It is thus wholly unnecessary to embark upon an evaluation of the evidence of the host of witnesses who were called herein. Sioni's sanitized version of its source and destination renders that exercise unnecessary. Sioni's evidence herein was, given its earlier non-incriminatory character, a shot out of the blue. In his revised version of the circumstances, the latter remained behind in the vehicle. He entered the premises and then narrated how accused number 1 came into Infinity at some unspecified time, sent Vuyokazi to call him, and then handed him the money with instructions to hand to Vumazonke. This shocking revelation was inimical to accused number 1's claim to innocence, but as the adage goes, even liars tell the truth sometimes. Sioni's disclosures, not unexpectedly, raised the ire of Mr. Price, who sought its expungement on the grounds of hearsay, but I allowed the evidence to stand. During his cross-examination, Mr. Price was thus constrained to exercise damage control, which he sought to achieve by the following assertion, and I quote, "I am not saying you are lying. I am saying you are making a mistake when you say that Christopher gave you 80,000 at OK Grocer to give to Vumazonke." Close quotation. Sioni's riposte was, and I quote, "I am not making a mistake." In evaluating the revised version of the source and destination of the 80,000 rand, it is apposite to refer to Exhibit AY1, where Sioni recounted having received the money whilst in a car outside his home on the evening of Jade's murder. In Exhibit V25, Breakfast confirmed that when Sioni entered the house after meeting accused number 1 outside, he had a bag of money and asked her to count it and leave 50,000 in the bag and the balance to one side. Sioni's viva voce evidence thus provides substantial corroboration for the content of both Exhibits V25 and AY1 and proves beyond any reasonable doubt that accused number 1 knew who the recipient of the money was. Further corroboration is to be found in the conversation between accused number 1 and Sioni on the evening of 29 April 25, where he says, "TS, you know why I'm actually stressing? I'm not safe anymore, because I have to run away even from Sizwe, because I told him what Sizwe said. That money was too little because now they are running away too. CPS, but it's because of them, Tando. They made it the way they did. They made it so big, but they have run away here. How many of them?" It is difficult to conceive of a situation where Sioni could be mistaken about the source and destination of the 80,000 rand. It was never put to him that he was being deliberately untruthful, and yet other witnesses had been castigated as liars for their testimony concerning money left at OK Grocer. The underlying reason for Mr. Price's mild-mannered disposition towards Sioni is self-evident. He was complicit in accused number 1's concocted defense and could accordingly not be rebuked for his faux pas concerning the 80,000 rand. As adumbrated herein before, this is the only aspect of Sioni's evidence which I accept as truthful, and it, coupled to the absence of any rebutting evidence by accused number 1, perfects the mosaic of the state's case against him. There is no dispute concerning the precise location where the deceased body was discovered. That she had been conveyed there in a vehicle from her home in Port Elizabeth, however, admits of no doubt. The evidence adduced by the state and detailed hereafter conclusively establishes that prior to 21 April 2015, Jade and her colleague, Ms. Swanepoel's movements, places of abode and employment had been monitored and kept under surveillance as from 9 April 2015. As I shall in due course detail, the data retrieved from the car tracking device installed in a white Toyota Etios, the Etios bearing the registration letters and numbers FYM 661EC, provide irrefutable proof that it was the instrument whence the monitoring and surveillance referred to was conducted, and wherein the kidnapping and ferrying of the deceased on 21 April 2015 was effected. The first inkling that the etios had been used to transport the deceased arose quite fortuitously when Warrant Officer Johannes Jacobus Bogus, one of the members of the unit, interviewed the owners of the vehicle. Before I analyze and evaluate that evidence, however, it is apposite to dispel the notion that testimony incriminating the erstwhile accused number 2, Sizwe Vumazonke, with the offences preferred against the accused, was inadmissible. Prior to the resumption of Botus's evidence in chief vis-à-vis the movement of the etios on the morning of the deceased's disappearance, both Mr. Price and Mr. Doberman objected to the reception of such testimony. The objection by Mr. Price was formulated thus: My Lord, since yesterday we have been taking instructions from the family, and we have spoken to very senior counsel throughout the country, because something has been worrying us from the word go, and I need to address it with your Lordship right now. Lord, we feel that we are being ambushed. I'm not talking about ambushed in the sense that we are getting very poor statements. I'm not referring to that at all, but from the word go, apart from Mr. Ndedwa, my Lord, we have just had witness after witness testifying about Sizwe Vumazonke's role in this case. Lord, Sizwe Vumazonke is not before you, and what makes it extremely difficult for us representing Mr. Panayiotis here, Mr. Doberman can speak for himself, is that we are feeling obliged to ask questions from a witness who is not before the court about a witness from whom we cannot take instructions. Now, Ms. Bakker and his attorney, we have obviously consulted with them, and they have very strong and at times, in my opinion, pretty good instructions to challenge various witnesses, for example, the cell phone experts, etc. But we are not in that position, my Lord. And what is happening here is that we are being forced to defend Vumazonke when he is not before this court and when we cannot defend him. Now, my Lord, my instructions are to ask your Lordship to one of two things. One, that this evidence relating to Vumazonke and any other further evidence relating to Vumazonke's role in this matter should be disallowed. He is not before this court, he is not an accused. Aligning himself with the objection raised, Mr. Doberman submitted that, my Lord, the difficulty is that the state is going to seek to rely on evidence against an erstwhile co-accused who is not before the court, which I am basically not able to test properly during the trial. The state relies on the doctrine of common purpose and also alleges a conspiracy with that particular accused who is no longer before you, my Lord, and who is not represented here. So in essence, accused number 3 and accused number 4 basically just have to accept whatever evidence is placed before your Lordship in relation to that accused. We simply are unable to test the evidence, and we have to face that evidence blindly. So in those circumstances, the question arises whether that evidence should be ruled admissible or not. My Lord, and just for the sake of formality, I'm going to object to that evidence being adduced, the evidence relating to accused number 2, my Lord, and I'm going to ask your Lordship to make a ruling now on that issue, whether that evidence should be allowed. So I note my objection, Lord, on that basis. I overruled the objection and allowed the further adduction of Botus's testimony. The general rule is that all relevant testimony is admissible unless excluded by a specific rule in the law of evidence. This inclusionary aspect of the relevant criterion was explained by Inna CJ almost a century ago in Rex versus Trapedo, 1920 Appellate Division 20 at P62 as follows. The general rule is that all facts relevant to the issue in legal proceedings may be proved. Much of the law of evidence is concerned with exceptions to the operation of this general principle, as for example the exclusion of testimony on grounds of hearsay and remoteness. But where its operation is not so excluded, it must remain as the fundamental test of admissibility. One of the myriad of issues which fall for adjudication in this matter relates to the question how Jade, destined to be driven by Ms. Swanepoel from her home in Deacon Street in Port Elizabeth to Ribbeck College in Uitenhage, ended up in the veld on the outskirts of KwaNobuhle. The evidence which the state initially adduced by Bogus was directed to establishing that she had been transported thence in the Etios which had been hired from Zems. Bogus had established from Mrs. Zulfa McCarthy, Zems' owner, that Vumazonke had hired that vehicle. Such evidence was clearly admissible, and, as I shall in due course elaborate upon, crucial. The objections raised with much hullabaloo to obfuscate the real issue had as its object the suppression of such testimony. I know of no exclusionary rule where more than one accused is charged, and prior to the commencement of the trial one dies, testimony implicating him or her in the commission of the offence or offences charged is thereby rendered inadmissible and to be excluded from the conspectus of evidential material. It is not an issue that the manhunt for Vumazonke was triggered by the revelations made by Sione, where after a tracking team which included Sergeant Tapelo Mabija, Siabulela Manakaza and Bogus set off on a fruitless search of him to Cape Town. It is apparent from their testimony that Vumazonke had however been forewarned of the police's hot pursuit and had returned to Port Elizabeth. The tracking team followed certain leads and observed him at a party in KwaNobuhle. Vumazonke left and proceeded to a tavern, surreptitiously followed by the tracking unit. Mabija recounted that Vumazonke stopped, alighted and spoke to an unidentified person who ran away when the tracking unit's members approached his vehicle. Vumazonke, who at that stage was seated in the vehicle, opened the door in an attempt to flee, and in the process of them trying to prevent his escape, he hit his head on the side against the side floor panel. Vumazonke was arrested and transported to the Kabiga Park police station. His possessions, including his three cell phones found in his possession, were booked into this SAP-13, to wit a BlackBerry 8520 model IMEI number 3612-570-054-59562, a battery, MTM SIM card number 28699299960, a 26B micro SD card, a white Samsung cell phone, IMEI number 3534-2006-329-0590, one battery, and a Cell C SIM card number 89270-760-1141-067-634, and an iPad with a serial number FSW LFY OAF196. Mabija recalled that the vehicle which Vumazonke had been driving was a silver grey VW Polo sedan bearing the registration letters and number CAW34942. The thrust of Mabija's cross-examination by Mr. Price related to the injuries sustained by Vumazonke and the alleged violation of his rights. Its aim was to establish a pattern of conduct by the police to corroborate Sione's evidence that he had been assaulted. The remainder of his testimony went unchallenged. It is not an issue that the unidentified male who fled the scene immediately prior to Mabija and the tracking team descending upon Vumazonke's vehicle was his distant relative, one Mr. Siloleko Leon Kirana. During the course of that evening, he had borrowed the vehicle from Vumazonke and had plugged his cell phone charger and cell phone in the cigarette lighter portal. When he eventually met with Vumazonke and left the SK2 tavern with Vumazonke and his girlfriend, Vumazonke had surreptitiously, and for reasons not germane to this judgment, handed his cell phone to him. When the vehicle stopped and the shots rang out, which caused him to flee the scene, he did so whilst in possession of Vumazonke's cell phone. As I shall in due course advert to, this is the very phone which Vumazonke accused the police of having stolen after his arrival at the Kabriga Park police station. Kirana's evidence concerning the circumstances in which he came to be in possession of Vumazonke's cell phone was assailed by Mr. Joberman as untruthful, but the criticism is unfounded and born of desperation. Kirana's testimony establishes that the number of the cell phone handed to him by Vumazonke was 0832691194. Its relevance would in due course crystallize. Mabija's testimony concerning the futile manhunt for Vumazonke in Cape Town was corroborated by Bogus, who had been assigned to the tracking team by Brigadier McLaren, the provincial head of the detective services in the Eastern Cape. Bogus narrated that he first saw Vumazonke at approximately 3 a.m. on 3 May 2014 and observed that his right eye was swollen. In his evidence in chief, he adverted to his role in returning the VW Polo to its owners during the course of that afternoon. Bogus had already established that the vehicle had been hired from Zem's car hire on 21 April 2014. During that telephonic conversation, he had arranged that he would deliver the vehicle to them, and duly did. McLaren, though not physically present at the scene of Vumazonke's arrest, was in the area, and it was to him that the tracking team proceeded on the arrest of Vumazonke. Bogus narrated that during the discussion with McCarthy, the owner of Zem's, he perhaps presciently, asked her whether Vumazonke had not previously hired vehicles from her. A perusal of the records, Exhibit U, revealed that Vumazonke had hired a white Toyota Etios bearing the registration letters and number FYM661EC for initial period of 2 days, but subsequently extended until 23 April 2015. Upon being appraised that that vehicle had been fitted with a tracking device, Bogus asked her whether she would be able to retrieve the data relating to the vehicle's movements on 21 April 2015. Bogus's account of the data displayed on the computer screen, and which would later be corroborated in all material respects by McCarthy, was as follows. Then I requested her to switch on the computers for me. I also informed her that she is not compelled to show me that, and then we switched on the tracker record of that vehicle, FYM661EC.